Good morning. The time for convening has arrived. Welcome to the GSBA Policy Workshop. If you're not sure if you're supposed to be here, take a look at your badge. Look for the word policy. If it does not say policy and you want to be here, you just need to go to the registration desk and they can make sure that you are registered so you can receive your credit hours. And want to say thank you today to our sponsors, Evolve and Davenport and Company, and thank you to all of you for being here today. We hope you get a lot out of it. We do have Wi-Fi access. If you go to Hyatt Meetings, use the password GSBA 2026. You can also access all of today's materials on our Feed Loop Go app. And if you need help with that, we'd be happy to assist at the registration desk. That is also how you will receive your credit hours at the end of today's workshop. So we'll talk more about that later. I don't want to spend too much more time, but I want to let you know that we have our usual cast of characters, as well as Lauren Atkinson, who is the new General Counsel for GSBA. We're excited to have her here today. We also have Phil Hartley, Corey Kirby, Beth Kinsinger, and Creighton Lancaster from PKKN. I hope you'll join me in welcoming them all to the stage. I know today will be very fruitful for you all. Thanks so much.
Welcome to the 2026 GSBA Policy Workshop. In an effort to connect with a broader audience, we are thrilled to announce that we will be utilizing a new resource. Our goal is to create more engagement with a younger crowd. Please allow us to introduce.
My board wants to policy all the time. Policy all the time. Policy all the time.
No, not that again. Welcome everybody, and please allow me to introduce my foster dog Zeus. Since Zeus is a rescue dog, we don't exactly know his age, but it's obvious from his language skills that at least in dog years, he's an elder Gen Z dog. So please give a warm welcome to your Gen Z language translator, Zeus.
Low-key, the lawyers are hella stoked to once again give a fire welcome to the 2026 GSBA Policy Workshop. We got a ton of tea to spill throughout the day. The legislature was hella active, and that's both fire and savage for public ed. Fam, the courts have been straight fire, no cap. We're low-key gonna dive into some recent cases and get the tea on First Amendment, and also cop the 411 on its roots. Bruh, let's get into it. We're about to dive into how you're rocking that Board of Education flow, and now you're straight up undercover judges, no cap. Low-key, we're ghosting for lunch and def some other breaks throughout the day, because the study session is going to be a slog.
Thank you for your attention. And now, we'll turn things back over to the other distinguished faculty of the Policy Workshop. Hey, good job, Zeus. You wanna go for a walk, baby? Let's go for a walk.
Good morning, folks. Welcome to the Policy Workshop in connection with the 75 years of GSBA. We appreciate you being here. We especially appreciate the help that Zeus has provided to all of our efforts. You will see his paw prints throughout the presentation. And we hope it provides some help for those of you who need interpretive assistance in this process. It is going to be an interesting, long day. Corey and I are going to handle the first session, and along with tradition, It's going to be about what happened in the Georgia General Assembly. And if you don't know, the answer is a lot. And the lot that happened was frankly very confusing. I want to apologize right away for all the words on the screen, but when you're trying to condense legislation that is 45 and 50 pages long, it takes a few words to do that. We're going to try to point out just the essence of things and the things that really matter to you as board members. We have some practical tips as we roll along, which we hope will be the points where you can go back to when you leave the conference and see the things that are most important that you need to make sure are being taken care of in your school district. That's the point anyway. If you have questions, Corey is here to answer every one of them.
Every time.
He will be standing up front during the break. He doesn't need to go to the bathroom because he's still a young man. And so he'll be taking care of any and all questions that you may have. Truthfully, we all look forward to being here in addition to the people that have been introduced and will be on stage. We have with us today from the firm, Apu Paul, Brian Smith, who hopefully is not wearing his Walmart breeches today. And we have Michael Gwatney, our policy coordinator, who works closely with GSBA and many of you.
We also have one other individual, Randy Farmer, with us from the firm as well.
Thank you. I didn't see Randy. I'm sorry. Thank you. All right. Anybody else I missed?
That's it.
Okay. With that, we are going to get started and get into the legislation from this last session of the General Assembly. And Corey, where do you want to start?
Well, why don't we start with the beginning? Phil's not incorrect, and I want to make sure I say it that way so we can do that. This legislative session, we had an enormous amount of bills that were introduced. More importantly, we had even larger number of bills that were passed this session than I think at least for the last 2 or 3 years that I can remember with that. One of them, I'm going to start being positive again, and Phil will be negative as usual. But I like this bill because it basically extends.
I don't see how you can be positive when you're talking about the Georgia General Assembly.
You have to work at it, but you give it a shot. This bill is an extension of a similar bill that we've had that allows certain educators who have retired to come back full-time, work for you all, and they receive not only their TRS benefits, but also receive a salary from you all. Now, the interesting thing is this. We've extended this bill through 2030, so that gives us a little extra period of time, and it's effective this July, and here's the interesting part, only if there's concurrent funding with that. Now, Phil will explain what that means later, I'm sure, but the good news is, number one, there is funding for this, and number two, we're going to start with this. Couple of things you need to know. First and foremost, to be qualifying as a certified, as a teacher for this, you have to have 30 years of credible service, have been retired for 1 year before they can come back.
None of that has changed.
No.
That's the same that the law has been the last several years. What has changed a little bit is that you can hire them back in the 3 highest areas of the school system's needs. And guess what? You get to decide what those highest areas of needs are. You're not dependent upon RESA. It's not the whole RESA district. It's district by district, and you get to make that determination. That and the extension are the biggest changes. We still have the requirement that they're going to keep, the educator will keep receiving all of their TRS, which is the incentive for them to come back, of course. but their years post-retirement aren't counting towards more TRS, okay? They're frozen where they are as far as TRS. The district's got to notify TRS of all the information so TRS can track who's doing what, and the contributions for both the employer and the employee's end are paid by the school district. There's nothing in the statute that mandates how these people or how much these people will be paid. So there's some degree of negotiation that can go on in that process. Educators like to treat everybody the same, but this may be an area where you want to think about how you deal with that in hiring back these educators if they're willing to come. I've told a number of people, once I get through a whole year of retirement, you can bet your bottom dollar I ain't coming back for anything, so. But that's just my feeling. That may not be your teacher's feeling, so we'll see how that works. All right, what else?
One of the other beneficial bills that
It's not
passed.
beneficial. Takes teachers out of the classroom. Go ahead.
Okay, you tell April that, because my wife was very excited about the fact that she gets an extra 2 personal days each year now. Instead of just 3, they get 5. Now, one of the things you want to make sure of is that your folks go back and you revise any employee handbook or anything else that you have that refers to 3 personal days, because it's 5. It's not like you increase the number of total days, but what you do is you get to increase the number of personal days that you get to use. My wife was very excited that she could now have a vacation of 5 days.
Let me poll your wife's parents, teachers' parents, students' parents, see how excited they are. Our General Assembly continues to add leave available, putting you in the position of finding substitutes, which are hard enough to find anyway. But in any event, this is good for teachers.
Negative. This is what I'm telling you.
Maternal birth leave. I was absolutely convinced when I first saw this bill that it was going to be unconstitutional. After all, you can't have a benefit that is just for females and not for males. And then I read the legislation, and I realized it's probably not unconstitutional because it's only for people that have given birth. And so if you've given birth, whatever sex you are, you're entitled to this benefit, okay? It works this way. All eligible employees, here's another leave thing, shall be eligible for 120 hours. That converts to how many weeks?
You want me to do math
3
early in the morning?
3 weeks of paid maternal birth leave for qualifying life events. They have to have been with you for 6 months, not for 1 year, which is what the FMLA requires, okay? Many of these provisions are similar to the PPL, paid personal leave provisions that was put into the law, parental leave, I'm sorry.
I wasn't gonna.
Thank you, I appreciate that. That was put into the law several years ago. Employees are eligible because they're eligible under the state health benefit plan. The qualifying event is giving birth to 1 or more children in a single or multiple pregnancy. When I first read that, I thought, how many times can you give birth in the same week? But my good friend over here and his wife have had 2 multiple pregnancies in their parenthood. And so
There will not be a third, that's for damn sure.
There is some degree of issue and confusion, just as there is in paid parental leave, with how this will be applied to events that are not full-term births, whether they're miscarriages, whether they are stillborn births, etc. We don't have an answer here. It does say giving birth to one or more children in a single or multiple pregnancy. They get paid time off from work necessary to recuperate as a result of the qualifying life event, and that's the terminology.
Unlike paid parental leave, maternal birth leave does give us a little more explanation. Here's the interesting part. They have to take it within 3 weeks of the qualifying event. If the leave is not taken within 3 weeks of the qualifying event, it's over. Now, that poses a problem in some situations. For example, let's say that the qualifying event takes place in June or July and they're a 9-month employee. Probably don't get to take this leave. Right. Moreover, if it happens sometime around, let's say, winter holiday, the first week, sure, but then they go on winter holiday, most likely that's it, okay? One other thing you need to be aware of, if they don't take maternal birth leave, they do not get paid for it. Very similar to paid parental leave from that standpoint. And then one of the last things that you want to be aware of, it's not just for certified folks, it's for classified folks. So if they haven't worked based on months, it's also hourly, so it's 700 or plus hours in the most recent 6 months.
Many of you have operated for years without particular rules or guidance on the principle that whatever the doctor says is how much birth leave the mother gets. And for the most part, you've sort of had this standard understanding that, you know, they're going to be out for 6 weeks. And they write their note and that's it. And that draws the line between birth leave, some kind of, I never know how to say this because obviously I'm one of those people to whom the law does not apply. But it draws the line between sick leave and parental leave, okay? This means 3 weeks does, but the 3 weeks is on top of the paid parental leave. It's extra. So if you have a situation where someone needs more time, that's available to them under paid parental leave, or they take the 3 week leave to recuperate, and then they decide, I think I'm going to go back to work for a little while, and then, I want to see when the child starts doing this and this and this, and want to be home with my baby, so they can take the rest of their paid parental leave and their FMLA later in the year that they qualify for. So it's going to get a little bit complicated, but this is just for recuperation during the 3 weeks immediately after birth. So, with all due respect, most of you in the room aren't young enough to worry about this. But if you have daughters that are in the school system, then you need to tell them, plan that pregnancy carefully. Take full advantage of all of this leave. So what rules do we have?
I'm not having that conversation with my kids. I'm just going to tell you that.
Well, you're sure not having it with April, so.
Couple of things y'all want to be aware of. You need to make sure that in your policies and in your procedures, you determine whether this maternal birth leave is going to run concurrently with FMLA leave, et cetera. You're asking me, I would think that would be the best way to go, but I'm not a board member, and so I don't get to make that decision. That's what you all get to make.
Yeah, I'm older than Corey. I'll tell you, make it run concurrently. You know, we want it to run concurrently so that we can get teachers back in the classroom.
Same guy who told me when I started, Corey, you're not a board member. You just give them options. So now he's all of a sudden become a board member, I guess.
I'm older now.
Nevertheless, the other thing that you all want to think about, and this kind of dovetails with what Phil was saying, you're going to kind of want to think about the documentation, if any that you want, that you're going to require from your employees to be able to provide you to determine and establish that they had a qualifying event.
Wait a minute, documentation.
Oh, God.
You walk into the central office and you say, here she is. I mean, you know, I was 9 months pregnant, you know. Now I'm not, but I have this baby. But in any event, whatever kind of documentation you want, you can require. You can't interfere with the leave. You can't restrain it in any way. It's a right of the teacher. But you can take action against any teacher who submits false or fraudulent documents to obtain the maternal birth leave. I don't even know what that means.
Yes, you do. You have a adoption, and they come and say, here she is, and there was no qualifying event.
And you don't think everybody's not going to know you weren't pregnant for 9 months?
All I'm saying is
You know,
that's what we're trying to
in
go
any
for.
event. All right, practical tips. This will require changes to your leave policy. As minimal as possible, we hope. One of the changes will just be changing 3 to 5. One of the changes will be to incorporate this birth leave into the section that's already there. So there won't be big changes, but there'll be changes. This personal leave, and Corey's already made this point, comes out of accrued sick leave. This is not additional 2 days. It's part of the accrued leave. Make sure you don't do it in a way that gives them extra leave. And you really need to we've got so much of this leave, family medical leave, paid parental leave, maternal leave, personal leave, sick leave. You really need to make sure that your policies are coordinated and clear on how this whole process works, both for your employees' benefit and for your students' benefit, frankly. All right, Excellent Teacher Preparation Act. I think we've been preparing excellent teachers, haven't we?
Yes, we have.
Okay. But now,
our legislature is very concerned about the teacher education programs. They want to make sure there's some consistency amongst each school that provides this. And so by next January, the PSC, along with 18 other acronymed entities, are going to develop this, what they refer to as performance measures, so that they can then go and evaluate each of the preparation programs to determine if they are meeting these particular performance measures. There is a whole lot of other information in this bill about what this entity does with the PSC and these measures, but quite candidly, I think the main thing that you all need to know is we're trying to come up with consistency amongst education programs in our colleges and universities so our teachers have similar preparation so that they can get into the classroom and hit the ground running.
I asked Dr. Barrow, who most of you know is the executive director of PSC, what he did to make the General Assembly mad, because they've added several requirements as to what the PSC is going to be doing. And it's not enough that they regulate the certification of teachers. Now they're going to regulate the certification of the education departments of the various universities and online programs. So we'll see how that works. Child abuse protocols, there was some additions made, but we don't have to talk about that because this was the only bill remotely related to education that the governor vetoed. So let's move from personnel to student issues. And this is where it gets really interesting. First, we're going to establish, or the State Department is going to establish, a pilot program to study whether and how to implement outdoor learning spaces. Now, I don't know about you. I realize I'm old. I get it. I mean, we had outdoor learning spaces when I was in elementary school. It was the teacher, and she'd say, "Oh, this is a nice day. Let's all go out there to the tree. Everybody sit around the tree. You know, we're going to have our lesson out there."
I thought it was in the cave with the paintings, Phil.
Actually, it was in the ark, and it smelled like the devil. In any event, so we're going to have this pilot program about the outdoor learning spaces. The DOE is going to select schools to participate. The board has to implement a program. DOE is going to evaluate after 3 years. But when does this start, Corey?
Why do you make me have to explain this? There is a problem with the bill. In the bill, it actually says it was going to start the 25-26 school year. So I don't know how they do that. I don't know how you go back now and do that. It clearly has to be some type of Scrivener's error that they have that. But long and short of it, I would suggest that it's going to start sometime this school year, this upcoming school year. And then you all can decide whether you want to participate or not.
You are allowed, authorized, but not required, to provide a hunting safety instruction in grades 6 through 12, beginning with the 2026-27 year.
Now, this has been a bill that they've tried to introduce for at least the last 3 sessions, or excuse me, to get passed, at least the last 3 sessions. So we now have that passed. Praise the Lord. We can.
My suggestion is you don't have this class anywhere near your outdoor learning center. Keep those apart, okay? But the State Board of Education has adopted content. Oh, that's what I thought. They will adopt content soon. The curriculum is to be based really on DNR hunter education courses. Many of you probably have had those courses. And the instruction is going to be provided by a DNR certified hunter education instructor. We'll see how that works and whether that person is more of an at-will contracted employee or how that will work, depending on how many people are interested, how many kids are interested in taking.
One of the main reasons Phil says that is because those of you who've gone through it know this is at maximum a 2-week course. So it's not like you're going to have an entire semester of this, or if you do, I don't know what you're going to talk about for an entire semester. So that may be one of the reasons why instead of hiring a teacher for this, you do some type of contracted services for somebody to come in and do that.
Our General Assembly over the last several years has struggled, to be nice about it, with the whole idea of how to allow courses, classes, programs outside of the traditional K-12 process and curriculum, okay? And this year, they just sort of, with all candor, they just sort of threw it all at the wall, and we're going to see what sticks, okay? So this bill deals with non-traditional programs. The state board's going to establish rules and regulations for by July 1st. So we do have a year for that to happen, governing non-traditional education programs and services, and that will include dropout prevention, high school credit recovery, opportunity for students to schedule classes outside the traditional school day. Whether that's going to be all those programs that deal with those issues, we don't know. We'll see what happens with this.
But pay attention to those 3 bullet points because you're going to see them again in 2 additional bills. As Phil said, the legislature really is harping on this particular issue.
The rules and regulations are going to require the provider of these to have special education services, remedial non-traditional education programs. I thought these were non-traditional programs. That was the point. But measurable objective performance standards, procedures for monitoring, whether or not these will be your programs in your school, or whether or not these will be the programs of other schools operated under the governance of other entities, we don't know, or both. So we'll see. We thought we were through with Dexter Mosley, but we weren't. So
beginning with the 27-28 school year, so you have 2 school years from now, you now have to allow virtual school students who are in your area to participate in extracurricular and interscholastic activities that you in your particular school district sponsor and are under the direct control of your school system.
Your area, meaning if you have one high school,
That's right.
Your county or city, but if you have multiple high schools, it would mean the attendance area for those separate high schools. The virtual student has to be enrolled full-time in a qualifying virtual school, which is defined as one providing solely virtual instruction, doesn't offer extracurricular activities of its own.
You know, I was trying to figure out exactly what school would qualify for this, and I came up with one.
One, yeah.
And that's it.
So far, yes. And it has to otherwise follow the rules. Here's the part you need to know about. Actually, you don't need to know about it. Your athletic directors and administrators need to know about it.
It follows very similar to the current
Right.
provisions that we have, that you have to get 30 days notice prior to the first semester, that the parent of this virtual student is going to want the virtual student to participate. They have to provide that particular principal of the high school that they're wanting to participate in, the notice that they're going to do this, and the specific extracurricular or interscholastic activity that they want their child to participate in.
Student has to meet all the qualifications to be on the team or activity, age, academics, behavioral conduct, living within the right zone.
That's right.
Et cetera. So all that's got to be provided, including documentation to the school.
The part that's going to be interesting, just like it is with current Dexter Mosley, is these students have to comply with the same code of conduct and disciplinary measures as students that are enrolled in your schools. Not sure how you're going to apply those.
I think that means with regard to their participation in the extracurricular activity. You're not going to monitor what they do
at home
at the virtual school.
Right.
As part of at least I hope that's not the intent.
The fourth thing is that they do have to complete and do any particular tryouts. So if you have a basketball team, or more importantly, a cheerleading squad, and they have tryouts, and students, not all students who come and try out make it, these students have to go through that same process, and they have to make it just like any other student.
Tad of a complication here that I've run into twice with Dexter Mosley is that the tryouts are generally the semester before participation takes place. So does the student enroll the semester before so they're eligible to try out? And how does that work? There's some discretion on your part to deal with that. For the most part, I think folks are allowing, and I think the General Assembly's intent was to allow them to try out in one way or the other in some way so they could participate if they made the tryouts. Here's the part that I don't understand. If the activity includes a competitive selection process, the virtual student is already in. Does that make sense? No. But it's there. It's very candidly, it's part of our preference by the General Assembly for alternative schools, virtual schools, charter schools, all that kind of thing. So there it is. Do we have to revise the policy? Well, it's not clear you've got to have a Dexter-Mosley policy. What you've got to have is regulations, procedures, something dealing with eligibility and all this that can go in your handbook, most likely, or other places. If you have a policy, you for sure got to revise it, okay? If you don't have a policy, you got to revise your regulations. And the handbook, what's really, really, really important is that you make sure it's available and accessible to those folks it's intended for, which is parents of virtual students in some way. So it's got to be on your website, on the school's website, etc. And my prediction is we're going to have some Georgia High School Association rules that might well add some considerations to this. Don't know that for sure, but we'll see if that doesn't happen in the process. Dropout recovery charter schools. I thought we just talked about this.
This is the second version of this. This is where the state board is going to create various rules and regulations that would allow dropout recovery programs and charter school petitions to address this. Again, remember, they have the same three things. They have to talk about special education services, they have to provide the various programs, and they also have to provide the measurable objectives that they're going to do. Just like the previous bill we talked about, this bill for those charter schools and for that program, same similar situation.
That gives you a definition and explains a dropout recovery charter school is a charter school that enrolls 6 through 12 and provides these programs that Corey was just now talking about. It does not include K through 5 students. Most of your K through 5 students do not drop out. At least until they get to high school, so in any event.
But this one seems to be a little different from the previous one, where the previous one seems to be, and I'll say it this way, seems to be focused more on private entities trying to come up with a program available. This one seems to be focused more on individual public school districts creating a charter program for their school and their students to go through to address it.
So now we're going to talk about commission charter schools. You want to tell us what a commission charter school is?
Basically, a commission charter school is a charter school that the state charter school commission has approved after the local school district has decided they did not want to approve that. So most of the time, if we're going to have a charter school in your area, the applicant is pretty much going to want you all to deny them so that they can become a commission charter school for alleged additional funding. I'm not sure there is additional funding, but nevertheless, there is allegedly some additional funding. One thing that they've changed that's up on the slide that you need to be aware of, the State Charter Commission is saying that they will not make a decision to approve or disapprove a state charter school application and petition until you all have acted first.
And you all will have to deny that.
That's correct,
to
until you get there.
Yes, right. Okay, now, this is an interesting piece of legislation. To be very candid about it, it arose out of those that wanted to form, now I've already forgotten the name of it. What's Charlie Kirk's group?
Turning Point.
Turning Point. Those that wanted to form Turning Point clubs, etc. And so this is the legislation. Many of you will remember that there is a federal law that deals with equal access, that says if you have non-curriculum clubs, that you can't discriminate on the basis of certainly religion And for that matter, you can't discriminate on the basis of politics to some extent as well. And there are other rules. Our General Assembly, and we'll see more of this later, absolutely loves to take a federal law, put it in state law, change a few things so that it's confusing for everybody to enforce, and we've got some of that in this bill. So let's look at what's involved.
This is a quote straight out of the bill, and it's very similar if you're familiar with the Equal Access Act. It's very familiar with that. And it basically just says public schools, it's unlawful for them, for those public schools that have a limited open forum to deny access or a fair opportunity or to discriminate students from those of whom who wish to conduct a meeting. Now that's the part that I see that's different than the federal Equal Access Act. It's substantially broader. But nevertheless, you can't discriminate them for meeting on in the school facilities on the basis of political, ideological, or other type of speech for that particular meeting.
We would have told you before the EAA, and certainly before this, that this was the law anyway.
Yep.
This is sort of standard First Amendment law. Once you create some kind of limited forum, then within the legal limits of that forum, you've got to allow anyone to participate to accomplish whatever the purposes are. But nevertheless, we put it in our state law. Corey is right. Watch that word, conduct a meeting, because that may be a real trap. It goes on to sort of outline that you're deemed to offer this fair opportunity to conduct a meeting if you uniformly provide that the meeting is voluntary and student initiated. Again, that's what we would have told you the law was anyway. If there's no sponsorship of the meeting by the school or any governmental entity or its employees or agents acting in an official capacity. That's a bit of a struggle for me because there are clubs and activities and certainly meetings that are sponsored by the school. And reading the act, I can't quite put all of that together. So that'll be something we'll have to deal with as we see litigation and questions come up.
Number 3 is important because I've noticed that our administrators are very concerned about this bill as far as how it relates to their ability to maintain order, decorum in their facilities. So it's clear that the meeting cannot materially and substantially interfere with the orderly conduct of the actual mission of the school district and the school itself.
And 4 is very much related to that.
That's correct.
That the meeting can't infringe upon the rights of other students. And 2 and 5 sort of go together, that individuals not affiliated with the school may not direct, conduct, control this group. Now, if we can't have sponsorship by school employees and we can't have control by anybody outside, I think that means the students can just run amok as they want to, during the process. It does have to be a student initiated, and there's nothing wrong, the law makes this clear, with having somebody there as a student, as the faculty overseer to, see what's going on and to report back to the administration. Most of you know what a limited open forum is. Corey just told you. I think you know what a meeting is, but look at this term because of its importance. Those activities of student groups which are permitted and are not directly related to the school curriculum. Immediately, I think of gather around the flagpole activities. And I think you will have students who want to show their support for the Palestinians by gathering around the flagpole, and that will be allowed. As usual, well, that's not true. As we said years and years ago when the EAA was in place, it is my belief that while this was modeled to allow one particular group, mainly conservative kids, to meet, you're going to see it broaden substantially, and some of the concerns are going to arise out of other groups that may want to take advantage of it. Here's the sponsor business that I was just talking about that I called an overseer. I can't put all this together, Sponsor is an individual who is in whole or part responsible for sponsorship of the meeting. Thank you. A sponsor is responsible for sponsorship. The term does not include a school administrator or a teacher or other school personnel. So who does it include, It's really interesting, and we're going to have to figure this out sort of as it goes.
I think one point, though, that Phil made is worth repeating. You can have an employee present at the meetings whose purpose is there to ensure that the students are following the code of conduct so that the students aren't running amok during that. But what they can't do is step into the sponsorship role and lead, participate, or promote the various activity and meeting.
And we have more public school students are permitted to engage, read this carefully, permitted to engage in political activities and expression before, during, and after the school day in the same manner and to the same extent that students may engage in non-political activities and expressions. So, if kids can gather in the lunchroom or the gymnasium or outside or wherever and gossip about what happened over the weekend, then they can engage in political activities and expression during that time. This to me is the club business we can sort of handle. We've been used to this. This to me is a broader expansion of that you're going to have to decide. And they may organize partisan or nonpartisan political groups before, during, and after school to the same extent you allow other non-curricular student groups during non-instructional times. That's something many of you have not allowed, and you may need to look at your rules to see about that.
What they also make sure of in this bill, it's something that you all already do, you're used to it, but if you have partisan groups, they have to have, and nonpartisan political groups, they have to have the same access to our facilities that each other would already have. You obviously cannot make a decision whether you're going to allow a partisan group to have access to your facilities based on the content of their speech or expression. And they should have the same method and opportunity to notify and announce and advertise their meetings just like any other group in your school has the same situation. Interestingly enough, the statute does not define political group. I kind of think that would have been helpful, but nevertheless.
Depends on how they defined it, but we're going to have lots of fights over it. We're going to have some fights over that. Let's hope it's not in your school district, Amen. But that will be an issue where there will certainly be some issues. Here's the other big change.
This one basically now says that students are allowed to wear clothing, accessories, and jewelry that display political messages or symbolism in the same manner and at the same situation and extent that other types of clothing and accessories that have messages and symbols are allowed in your district. So you're gonna have to look at your dress code, and you're gonna have to determine whether you allow students to wear certain non-political type of symbols on their clothing. If you do, then you're going to allow students to wear various political symbols on their clothing. So you really have to go back, make sure your superintendents and your administrators are together on how you're going to do this. We initially talked about it and sort of joked about it a little bit, that you may wind up just having uniforms to avoid all of this. But it's something that you need to be aware of and pay attention to.
I think we've covered most of those 6 requirements that are to be followed, and we'll see again how that goes.
We've talked about this as well. It's very clear in the statute, and the legislature wanted to be very clear. You all and your administrators still have the ability to provide control and direction over their school and the students in there, even when they are involved in these type of meetings.
And as you see, you can obviously do what's necessary.
That's right.
To maintain that control and to keep conduct from becoming inappropriate. And you can enforce student attendance policy so that kids cannot engage in political activities when they're supposed to be in class, okay, or otherwise. So you need to review your handbook language, maybe your policy, if you have an equal access policy, to ensure that non-compliant language is removed as to student clubs. That will be a pretty important issue you're going to have to look at. You've got to have a strategy for how you respond to these kids that want to form a student club, a political club, and or want to gather for political reasons. Dress code revisions, Corey's already talked about. Lots of, that's not true. Some folks in the past have said, this is way too much trouble. You can wear whatever you want, but it can't have any writing on it, okay? So it doesn't make Nike happy, but whatever it may be, but it can't have writing on it because we don't want to be alleged to discriminate. Okay, you are not alone, Corey.
Thank you, Phil. I appreciate that. I feel the love right there. If you all in your district issue student IDs to students in 6 through 12, then you have to include this specific language on your ID, probably on the back of it, and it's for this school year. So be aware that if you already have printed these or ordered these, one way to address this would be just to get a sticker, print this statement on it, and stick it on the back of that particular ID. I'll tell you, I did not know where 988 goes. It's the National Suicide Hotline. Don't know who's on the other end of the phone or the text when they get it, but at least that's where it goes, based on my understanding.
And this is the negative, cautious, worried, having seen everything out of this. I understand this. I understand the point of this. Does it open a limited open forum? What if some other group wants to put a message on their on your student ID? They'll start looking like the IDs you're all wearing for this conference, at some point. But
have to have QR codes there next year for that.
Yeah, but in any event, we'll see whether that comes up. It is for this year. Corey's already told you that. Tell us about completion special schools.
This is the last of the 3 bills that we were referencing. This addresses the specific completion special schools. You may know them as Mountain Education, Coastal Plains, etc. By this June and this December and every year thereafter, your completion special schools are supposed to provide you certain information. They already do this, but now we have specific dates that they have to. They're supposed to provide you with updated descriptions of the programs that are available, detailed information on how students and parents are supposed to register for the classes and what classes they can attend. You're supposed to provide that information within 7 days of receipt to all students and parents, and you're supposed to put it in what they refer to as a prominent location. This is my favorite part, frequented by students at each high school. I'm not exactly sure where that would be. I mean, I guess you could post, well, forget it, I'm not going to say it. I'm just going to leave that alone. Good luck in finding that spot. But nevertheless, you're supposed to do that, and you're supposed to provide it electronically to parents and students as well.
And there's a little more.
There is. What it does is it really does help. It basically, and Phil's going to get a little nervous when I go off here, but it basically goes back to what it used to be several years ago. We know we have a much easier process now to enroll students in these particular special completion schools. They have a process. You all are supposed to assist these special completion charter schools. I always say the charter part. Special completion special schools. In enrolling these students, you're supposed to provide these schools with the names and information of students who have dropped out, so that they can then in turn reach out to them to see if they would like to continue their education.
One of the new requirements, although some of you are already doing it, is that the special school and the school they serve the most, I guess, have to have a collaborative agreement as to how things work. You know how education works. Somebody, probably, hopefully the special school folks, maybe the State Department, is going to develop a form. Look over that carefully. You may even want your lawyers to look over it before you adopt the first one. After that, it's a matter of, are these the same or are they changing? Okay, but that's something that the school district has to do to adopt this collaborative agreement. Foster care children. We cannot decide what to do with these kids that are in state custody and whether we want to make sure that we have time to get all the records that we need to understand their needs, or whether we want to get them in school, let you worry about it, and then get the records as we can. You know that the safety bill several years ago, 2 years ago?
Last year, 268.
Last year, wow. Time flies when you're having fun. 268, seemed to give you a little more control over this process to make sure that you had the necessary records. I'll come back to the first thing in a minute. This says no school shall fail or refuse to immediately enroll a foster care student, and no in circumstances later than 3 school business days. So immediately doesn't mean immediately, it means within 3 days. Upon following the receipt of a completed enrollment registration form, which you may remember is supposed to include essential documentation.
Critical records.
Critical documents from where they came, from the last school attended. And schools over the last 2 years. In fact,
correct, up to 2 years.
I think, as
yes,
I remember, okay. But, having said all that, we take it back and we say, you can't be so strict about enforcing that as to unreasonably delay the timely enrollment of foster care students, whether you enroll them permanently or provisionally while you get the rest of the documentation. Okay, It's a bit of let us have it both ways, if you want to know the truth. The top part is important for many other reasons. This bill, like so many other bills, we had a number of Christmas tree bills this year where we added ornaments onto it as we went. And this bill actually includes definitions of school days, school business days, etc., and changes a number of code sections. So the next time you have an issue that says you have to do something in so many days or in so many school business days, make sure you look at the new law, and make sure your understanding is the same as what the law has provided. But back to foster care students. If they're not timely enrolled due to a lack of these critical records, is that right?
You got it.
Critical records. Then you've got to provide the parent with contact to the RESA Student Affairs Officer. You remember that from last year? The RESA Student Affairs Officer. I bet you all know exactly who that is. And the Chief Privacy Officer at the State Department of Education. I bet you know that person as well. And you've got to provide them access to that. And the DOE is authorized to require the school to comply with a certain corrective action plan, etc.
This provision really doesn't change the enrollment part that we got last year in 268. You still have to go through the process of making sure that if you can't get these critical records, you have to involve your RESA and your student affairs officer. They have to try to reach out and try to get these records. The interesting part that I see with this is when you're dealing with foster students and children, you have to reach out to the parent. That's the part that I'm trying to figure out exactly who that's going to be. Is that going to be the foster parent themselves, which I think it should be? But sometimes when you deal with DFACS, they start suggesting that the foster parent doesn't have any authority because they're under DFACS care and authority. So it kind of makes me a little concerned. I think in some of our materials that we come up with, either our guidance or what have you, we can say specifically in there, we will contact the parent or the enrolling parent, however we want to do that, to make it a little clearer.
Again, this will require either revisions of your enrollment policy or more likely just revisions of your procedures to ensure compliance. The most important people in all that is whoever's doing the enrollment. The last thing you want is these folks not understanding the timeline and that they need to move on these things. So in some way or another, you're going to be modifying your enrollment process to take into effect this law. This is mine, as you can tell. If you want information about a newly enrolled student, pick up the phone and call somebody. It's easy enough to scan them the consent form, to scan them the enrollment information, and say, what can you tell me about this kid? We've got to enroll them tomorrow. What information can you scan to me? Have that conversation so there's some sense of urgency on that side as well about what's going on. And finally, in my experience, long though it may be, you don't want to antagonize foster parents. Foster parents need to be your friends. You're going to have to deal with them, not just with this child, but likely with other children. So you want to try to work as closely as possible, keep them in the loop, etc., and get their help in getting the information you need to effectively enroll the child. Okay, we're going to have to do these next as quickly as possible. Math matters. And we'll turn to our mathematician, Kirby, to explain why it matters.
Thank you very much. You all realize, and we actually mentioned it last year with all the emphasis on literacy, we told you to get ready because we expect there to be another bill on some particular subject. Well, congratulations, that subject is math. Now what's going to happen is this January, the state board is going to adopt various contact standards, etc., for advanced math classes for grades 8 through 10, and it has to include, at a minimum, advanced algebra. Folks, this is something most of you probably already do. So if there is a positive thing to say, an optimistic thing to say about this, most of this is things that you all already do in some form or fashion. So it's not like you're going to have to reinvent your entire math curriculum. But starting with 27-28, this is how it works. Grades 6 through 10, you have to automatically enroll certain students that hit a certain level on their end of course statewide math assessment for the prior year. And then they would be assigned directly to one of these advanced math classes.
But of course, you can't have an automatic something to happen without allowing a procedure for opt-out for parents. So parents can opt them out of that. Now, I find this next part interesting. If a student receives not the distinguished learner category, but the proficient learner category below it, then the parent can request that the student be enrolled in these advanced courses. The LEA can approve this request or require a placement committee meeting, not an IEP meeting, unless they're already under an IEP, with the parent or guardian to talk about whether the student ought to be enrolled in advanced classes or not.
The legislature goes through an awful lot of information about these kids in these advanced math classes and the kind of things, supports, etc., that you all need to provide. If you look at the list, this is things you all already do. Just be aware that they require this. There's additional instruction. I don't know what high dosage tutoring is. I'm sure Phil does because he's all over that high dosage stuff right now. Nevertheless, one of the things I do want to point out is technology-enabled.
I need some high dosage. If any of you have it, it would help me get through the rest of this conference. So let me know.
But they do point out that you need to have technology-enabled activities. I think that's the legislature's way of focusing on maybe AI activities and AI in these particular classes.
LEAs have to provide information to parents or guardians who score proficient about are distinguished about how this works, et cetera, et cetera. You can imagine why that is. By October 1st of 2028, and each year thereafter, the Department of Education is going to provide a report to the General Assembly giving them numbers about how many have qualified and all that kind of good information.
It worries me when our legislature expects to get this kind of information about how our students are performing in a particular curriculum, because it seems to me they want to get further down in the weeds with these kind of things and start suggesting to you all how you all need to teach these things to those students.
It worries me when our General Assembly gets involved in curriculum issues at all, but that's just me. The PSC, here we go again, is given responsibilities to recommend to the Board of Regents standards that are designed to ensure that post-secondary students, those that are graduating from their programs, complete the necessary certification programs to do all of this that we've been talking about.
I think it's another part of the education preparation program and the legislature wanting to make sure that they're meeting these particular qualifications so when they get out, they can step right into your school classroom and hit the ground running.
This is likely not a policy issue. You have 1 year to prepare for the curriculum, to process and to train teachers. Handbooks and guidelines do need to be developed to provide parents with information. Hopefully you have some assistance from the State Department of Education on that. You see those clock right there? That means we've got to hurry.
All right, let me do this one very quickly. All right, this is a horrible situation. The long and the short of it, now there is a process that parents and you can use to provide a high school diploma to specific students who are medically diagnosed with terminal condition and they're receiving end-of-life care. There's a process that the parents go through to request this, then you request from the state board a waiver for graduation, and then the diploma can be issued and provided. Okay?
Hopefully everybody moves quickly because the bureaucracy is such that you want to get this done as quickly as possible.
Dual achievement, separate from dual enrollment. We can't leave that alone. We always have to change it. Now we've changed eligibility requirements for students to come in there, including age requirements, etc. Long and the short of it, please be aware that this doesn't happen until July of 2028. So we're not going to go through the specific requirements. One, because I expect them to change between now and July of 2028. And two, because Phil's already gone on to the next slide.
Most of you have heard at least about the Early Literacy Act. Board members need to have a broad understanding, but are not going to be the implementers. So, as Corey has said, you don't get into the weeds. Look at the first three words. Subject to appropriations. Folks, and I'll mention this again in a second, the day will come when money is not falling from the sky. It may have already started. And then we'll have to see what the General Assembly does in terms of cutting things. And you need to be aware that all of this is subject to appropriations. You also need to be aware that this is a reimbursement program. It's not in the formula. It is something you will be reimbursed for as you see there, and you will get one school-based literacy coach for each school that has a K1, 2, or 3 grade in it, okay? 50% of the amount if the school has 200 FTE or less. We're supposed to have rules for that by August the 1st. We'll see what happens with that. The state board with OSA is to develop these minimum qualifications for the literacy coaches. You're going to have to pay close attention if you can figure all of this out. The qualifications have to include, you see all that, I'm not going to read it to you. The duties include working and coaching with educators, developing plans. They have to spend at least 70% of the day in the classroom. That does not mean they teach 70% of the day. They may be observing teachers. They could be co-teaching. They could be model teaching. They could be a lot of things, but it doesn't mean that they are there teaching. School-based literary coaches shall not be authorized to perform bus duty, hall duty, lunchroom duty, anything else like that.
They're not an administrator. They're not supposed to be invited or required or even permitted to attend placement committees for
that
these
one makes
students.
no sense to me.
None.
That's for another day. Okay. And they cannot be designated as a teacher of record.
Now,
this is where it really gets confusing.
These next two employees that we talk about are not your employees. They're employees by your RESA. So your regional literacy coach and then your leadership literacy coaches are hired by and provided by your RESA for your system and your administrators.
School-based literacy coaches, regional literacy coaches, regional leadership literacy coaches. You're going to have a chart to keep up with who everybody is and what they do, okay? But Corey's already told you that they've got to work with all these people, including you, to help develop it. If hiring more people will make our children literate, this is a step in the right direction. So we'll see what happens in that regard. Again, we got to have the minimum qualifications, the same essential qualifications for these regional leadership literacy coaches, et cetera. And then we turn to materials.
When using, it's the same situation that you currently have. You have to ensure that you have high quality instructional materials, and this is the important part, aligned to the science of reading. You already have to do that. If you choose literacy materials that are not the ones appointed by and determined by the State Board of Education, there's a process you have to go through in order to make sure they're high quality.
This has been in the law for a while, so most of you understand this. Here is something new.
Yes.
Each school has to have a unified literacy plan, and you can read that at your leisure. You have this information in your feed loop.
The last two bullet points are the most important. You have a deadline, and more importantly, you have teeth to this one. If you don't meet that deadline, then you can see the various penalties that can occur.
If that's not enough, we've got a literacy coordinating committee operating within OSA, which is no longer named OSA, but that's...
I don't know what it is.
Neither there. And we've got a Georgia Literacy Task Force, which will be convened. I said, if added people will make our kids literate, we have done it. So we'll see how that works out. There's less a policy here than this focus on the Unified Literacy Plan.
Yep.
That's the deal, sort of like a safety plan for your school. And that's my joke about a line chart to keep up with all these positions and what they do. We have changed the compulsory attendance law. Some of you have been pushing for this for years, and the compulsory attendance law now requires students that are 5 through 16 to attend school. Obviously, they could attend a private school, they could be homeschooled. All children that are enrolled for 20 school days, it used to be prior to their 7th birthday, is now prior to their 6th birthday, are subject to the compulsory attendance laws of the state. You can't keep kids in kindergarten more than 2 years unless they're really big and can throw a football with a nice spiral on it, then you might consider that. But and each child enrolling in the school for the first time is eligible for enrollment in the first grade under those circumstances.
There's a process that you're going to have to...
This is the other change that's important. Yep. Go ahead.
There's a process that you all are going to have to use to determine if a student is ready to go from kindergarten to first grade. There's an entire process. We've kind of outlined it pretty well for you in our slides. That same process is going to be used for students to go from first grade to second grade. And it needs to be involved. The interesting part that I see, parents are involved in this, and it has to be, everyone has to agree and be unanimous in that to move forward or not.
And it's the same as any other gateway grade. The other gateway grades that we have, it's just adding one. This is just like moving from grades 3 to 4, moving from grades 5 to 6, moving from grades 8 to high school. You've got to have a process to promote those students. And if they're not going to be promoted, some kind of meeting to let the parents know about that and what you're going to do about it. This is going to be changes in your enrollment policy. There's going to be changes in your promotion retention policy and rules. Will you need more K through 2 students?
Teachers.
That depends on how many kindergarten kids you have now, and what the effort is to let parents know about this new requirement, compulsory attendance requirement, as to whether or not you do, and how many of these students you now retain before you put them in 3rd grade. I really think if you can find a way to leverage all of the people involved in this Literacy Act and help struggling K through 2 students, there's some good stuff here, okay? It is really involved, complicated, lots of folks, lots of people, but I think potentially there's some good information here. This is for you young'uns in the room. All of us old folks, take a break. You can sleep for a while. Tell them what it says.
Okay. Beginning in 2031-2032 school year, all graduating students are required to take a certain course in computer science or a CTAE course that has computer science embedded in that.
And we won't even be talking about computer science by then. We'll be talking about not even AI, we'll have it called something else. Computer science won't look anything like it does today, but man, we're ahead of the game here. So, you know. This is another one that bothers me for obvious reasons. You've got to allow representatives of patriotic society that ask the opportunity to speak to parents to promote good citizenship, civic education, and patriotism during school hours. There's a list, there it is.
That's the good news. There's a list we can now determine if they're patriotic
and you
societies.
can see if they're patriotic. And basically, it's Boy Scouts, Girl Scouts, and all these other folks. They speak during school hours. They have to submit a written request. The request has to include all these stuff. You can read that as well as I can. Here's my concern. I come back to this over and over. This is the First Amendment conference, folks. I'm just telling you. Have we opened the door? I mean, if we say these patriotic societies can, who's to say I'm not a patriotic society? I mean, I'm not on the list, but I'll be glad to talk about good government, civics, and all this other stuff. We'll see. Hopefully, when you get those questions, you can call Corey or Creighton or Beth or Randy or somebody at the firm and get a decent answer.
We'll hand out your cell phone number.
Yes. So if there's a problem with any of your policies, you might need to look at it. Some of you may have policies that prohibit this very thing, groups coming onto campus and speaking. I just said that. Does it create a limited open forum? Cell phones is pretty easy.
Very easy.
27, it's going to apply K-12, not just K-8. If you want to do it earlier, go ahead, be our guest, but you got to do it by 27, 28.
One of the specific requirements requires you all to come up with guidelines for various things like dual enrollment, work-based learning, et cetera. So that's something you'll have to think about when you're working on this.
Some of you created a policy for this. If you did, you'll have to change it. It doesn't require a policy because the law tells you what to do. But if you have a policy, you'll need to make those changes. Review your handbook provisions, especially about ensuring parents and students that they're aware of the new rules. That's more important to me than worried about a policy. This removes a requirement that frankly I didn't know was there to involve a licensed physician or other person authorized by the medical board with the district's AED program. I thought the district's AED program was we just hung them on the wall and they sat there, you know. And it removes the requirement to report any use of those AEDs to the physician or authorized individual using the programs. This one's fairly easy too.
Yep, starting in 26-27, if you have a pre-K program, and then you also have an after-school program. Long and short of it is, however you allow students to enroll into your pre-K program, you also have to allow them the same method for your after-school program. So if it's first come, first served for pre-K, same thing for after-school. If there's a lottery, same thing for after-school programs.
So they now can participate. There's ways of getting a waiver for this from DeKalb for 1 year. You can look into that if you wish. Probably not a policy involved here. Most of you don't have policies for your after-school programs, but you do need to look at your rules and requirements for those after-school programs. This is easy.
Hope Scholarship, now you can use advanced fine arts courses and grades to determine your eligibility for students for the Hope Scholarship program. I think it's a very good idea for those kids who spend a lot of time in the fine arts area. They can allow use.
Let me warn you, we're going to run over just a little bit, but we're going to give you your full break, and we're going to catch up before lunch, okay? Taxation and finance. Boy, if there's anything they talked about in General Assembly this year, it was taxation and finance. So, Corey's learned it all. He's going to explain everything to you, just like he explained 581 last year, and all of you opted out
2 years ago.
before you opted in, before they opted you in, and everybody's, well, never mind, you explain it.
Okay, first and foremost, if you go to the General Assembly's website and you search this year for Senate Bill 33 and it comes up with hemp issues, that's the bill, okay? What happened was during our legislative session, the last day after midnight, this bill wasn't passing. They grabbed the hemp bill, stripped it, and put this in. It literally took about 30 minutes from what I understand from folks who were there. Having said that, long and the short of it is this. You're going to have to remember back to 2024 when we had House Bill 581. That gave you all the opportunity.
I can't remember yesterday, much less 2024, but anyway.
Fair enough. Peptides, Phil. Those are good for memory and things. Nevertheless, what you have to do now is it eliminates that ability of you all to opt out. So congratulations, those of you who opted out, you're in. You all are now subject to a floating homestead exemption. Every district in the state is now subject to a floating homestead exemption.
Even though we have a constitutional amendment that says you could opt out under rules set by the General Assembly, well, they set the rules. You can't opt out. So
there's also a provision in here that makes it easier to transfer the homestead exemption. What I want y'all to be aware of is a couple of things, okay? First and foremost, remember this. The floating homestead exemption really addresses how high your appraisal and your evaluation of your property can go. It does not affect, that's not the case. It has not changed your ability to raise your M&O up to 20 mils, okay? All it says is how high the appraisal can go for that particular year. It's floating. There's an ability for your local tax folks to determine what, inflationary rate they want to use in the bill itself. It references CPI as an example, and quite candidly, I think that's what most folks are going to use. It's readily available. It's a standard situation, so be aware of that. That's what's going to happen. If you remember, last year, I'm waiting for him to say something, there was Senate Bill 92 that addressed those of you who had opted out of House Bill 581. And it required you all to put these really just onerous statements in your tax notices and your tax bills that said, oh, you know what? If you don't like your taxes because you think they're so high, go see this person, call them at this number because your school district did not opted out. That only goes into effect for those districts that don't have or not having to address a floating homestead exemption. All of them now have that.
Right.
So my hope is none of you have to put that godforsaken information on your tax notices or on your tax bills. So hopefully that's a good thing. Now, a couple of other things they do with Senate Bill 33. This is the weird part, because if you remember, our legislature and wanting to propose, oh, everybody should stay in House Bill 581, they said they were doing this because everybody had such a huge reserve. You all had millions of dollars in reserve that, quite candidly, would basically pay for your school system on average 3 to 4 months. Anybody who has a business knows you need to have some type of reserve. But they were fussing about it. This bill actually allows you to increase your reserve an additional 10%. Now, that worries me.
And you've also got the good news that your 5 mil share and equalization is going to be calculated in a way so as not to include any local exemptions that exist. And for some of you, that's really good news because you got tons of local exemptions. So that will be taken into account as you do that.
This bill is different than Senate Bill 33. And if I can go through it relatively quickly,
Please.
Long and the short of it, this requires your local tax folks to come up with a list of those individuals who receive homestead exemptions. And they are supposed to provide those and have those up to date. We have found that there are several districts, quite a few actually, whose local tax folks don't have
no
a list,
idea.
can't keep up with it, and have no idea who should and should not be on this list. I like this aspect from that because now hopefully we're going to have some list that may be accurate.
And I doubt that very much, but that's Corey's problem, not mine. This will allow some changes in how the State Department of Education can advance funds, State Board of Education, to local school systems in an amount equal to 50%, which is an increase. The request is made either by the school system or it could be made by the state auditor who says they need more money. Sorry, they need it now, So either way, the state auditor provides a written opinion that this is necessary and appropriate. The school system can request modifications to the plan, but that's really up to the state auditor. You're going to do whatever they tell you if you get into the need for an advance on your state funds in any such way. You're going to have to adopt a resolution, so you're on the record with regard to this. And the state auditor has to put this recommendation that we just talked about in writing as well, so everything is documented.
The legislature really has put a lot more power in the audit department's hands now, not only with this, but the bills that we're going to talk about. I can tell you, I've talked with the folks at the Department of Audits. They don't seem to be too happy with having this amount of power, but nevertheless, it's there.
The State Board of Education is now required to have at least one standing committee. That's an audit committee, and this committee will review reports on the status of moderate and high risk school districts, state charters, completion schools, you see that, make routine examinations of financial reports twice a year. State Health, TRS, PSERS has to report that they've received all the money they're supposed to, or what the status is of those, and those reports get forwarded to the Department of Audits. The local school districts and other LUAs, if you will, have to have an annual audit report of the financial affairs of the funds submitted to the Department of Audits by December 31st, and that's got to say we're ready for the audit, and it's got to also certify that we've paid all these state fees that we're that's not even right. You know what I mean. We've paid TRS, we've paid state merit, et cetera. Premiums, thank you, sir. Mm-hmm. Signed by the superintendent, the local CFO, and the chair of the local Board of Education. So you may want to pay a particular attention to that. The failure to comply bumps you to the top of the list. You're now a high-risk school system with all the consequences of that. What is the DOA going to do, according to this legislation, by July 1st to monitor the fiscal conditions of LEAs?
They're supposed to come up with a new plan, and I know they're working on it. And they basically are going to go through this plan to look at various factors. There's at least 10 of them required by this statute to determine whether you all are appropriately and accurately monitoring and maintaining the physical readiness of the school district for this. Now understand, this program does not go into effect until 28-29 school year. What they've come up with is a four-tiered situation and framework. Candidly, if you wanted me to boil it down, you want to be tier number 1. You do not want to be 2 through 4. 2 through 4 is bad. 2 through 4 requires you to go through a whole lot of other steps. And let me tell you something, they're a lot more difficult and a lot more involved than just going to some training that you have to sit through for a while where your superintendent has to go and then comes back and grumbles about it. This one has some teeth to it. And it's going to be a little difficult.
The Audit Department, State Board of Education, OSA, State Charter Commissions has to have their rules in detail, the conditions and indicators for each of the tiers, the conditions for which a local school system can move up or down from one tier to another, the state level monitoring that will take place, and a strict compliance standard to be applied, including at least any intervention plan applied by the local board. And here comes what
If
Corey
you
was
are
just
moderate
talking
or
about.
high risk, that's tiers 2 through 4, then what has to happen is you're going to have to go through and you're going to be audited by the Department of Audits. And unfortunately, it may be another audit involved there. And if they find out that there's any irregularities or deficiencies in fund accounting or whatever, that could be significant errors of physical concern, then they have to submit their response within 60 days. You have to determine whether you agree with it, you provide a response to them, and then you work out a plan that you all are required to comply with to try to move yourself from tier 4 to tier 3 to tier 2 and hopefully to tier 1.
If you're designated as high risk, then there's a provision that authorizes the State Board of Education to amend or terminate the contract on notice to the DOA flexibility contract.
Right, so if you're strategic waiver, they can terminate that. If you're charter, they can terminate that as well.
This is put in several places so you can get it. Superintendent contracts can, for high risk
That's right.
school districts, cannot allow the superintendent to have a longer term than 12 months. It's a little difficult to frame for your contract, so you need to look at your lawyer when you redo this, you redo your contract, because you want to get it right. Otherwise, you've got a contract with the superintendent and a state law saying you've got to shorten it.
That's right.
Which is a legal problem. I don't even know what this means. You got to keep up with how many of your school technology devices break, okay? And how much it costs you to fix them. That's it in a nutshell. This is the bad news. Student scholarship organizations, there's an expansion of eligibility to military service members stationed in Georgia, to those with, you can read the whole list, basically disabled students. General Assembly members are not allowed to receive any income from the SSO, which is interesting language. Prohibits virtual instruction to out-of-district students if the local school system has a CCRPI score lower than 65. So those of you who may have virtual schools statewide, you're not allowed to do that unless you've got a higher CCRPI score. And you've got to provide a complete list of out-of-system students that receive virtual instruction twice a year, as you see there, and those kids can't be included for purposes of qualifying for equalization monies.
This is the bad
This
part.
is the bad part. It keeps raising the cap. That means more and more money is going to these private schools through the tax credits that the SROs control.
They raised it another $30 million.
All right, we're going to try to do this quickly, but this may be among the most important things we talk about. Probably should have put it first. For those of you in a city school district, it used to be that if anybody really got mad at you and wanted to do away with the school district, they had to get a referendum signed off on. They had to get a petition signed off on by at least 25% of the voters. It's now down to 10%. In some of our small independent systems, that's a big change, okay? And only qualified voters residing in the independent system can vote, and if approved, they become part of the county system, and the county system has to figure out what to do with them. So that's an issue that may come alive here. Board member removal, all of you may remember, many of you may remember, several years ago when they put into place the law dealing with accreditation that allowed the state board to remove anybody from the board that was responsible for your accreditation reaching a certain level before it was lost. We've added to that. The state auditor now has to notify the state board within 3 days if the school district is designated at the highest level of monitoring. That's high risk, right?
That's, yeah, Tier 4.
Tier 4. If the local board member, school system, or superintendent is subject to an audit finding of financial mismanagement or misconduct, which is different from a simple audit finding, right? I mean, this is you really did something wrong personally in some way. The state auditor has to notify the state board of that. And then it works very much like the other provisions in the law. The state board audit committee, upon recommendation of majority vote of the state board, there's a hearing conducted by the state board, potentially and probably a recommendation made to the governor to remove those eligible members. Obviously, we're not talking about folks that may have been just elected. We're talking about folks that were there at the time that all of the financial issues happened that have led to you being reported.
This is something that Phil discussed previously. Long and the short of it, by this July, if you are going to enter into a new contract or extend the contract, you have to have specific language in your superintendent's contract that basically say that the superintendent contract, by an act of default, which it defines what that would be, can be terminated for various aspects of that.
Speaking of creating laws that already exist, we now have to create a statewide Title VI coordinator. You've already got provisions for Title VI. You've already got a policy for Title VI claims, but this requires the department to designate a Title VI coordinator
For K through 12.
dedicated to monitoring complaints. It's the intent that we not discriminate. Thank you, General Assembly, for telling us that. The coordinator is going to develop a uniform complaint submission process. That may change some of the forms you're using now, or even some of the procedures you're using now. Receive, document, investigate complaints If the State Department starts investigating complaints, we got problems. Any of you that know anything about the special education complaints process knows that 8 times out of 10, they're going to split the baby somehow. So that's a potential issue. We'll see how that works out. If they determine the schools failed to comply, then they come up with a corrective action plan. They monitor that, make recommendations to the Department of Education. If it's not resolved, they can refer it to the USDOE OCR, which is interesting given what's going on at OCR and USDOE now, but we'll talk about that when we come back from break. Submit an annual report. They're doing all kinds of reports. Consult and develop policies and procedures. And in general, implement the state's compliance with Title VI. Title VI, in case you don't remember, involves discrimination based on race or national origin, okay? That's the provisions of Title VI. Then we've got all these enforcement rules that you can read yourself and get into. We're going to have to incorporate this somehow into our policies. We need to know what the State Department's going to do to know exactly how to do that. We've got to be prepared to incorporate these procedures into our complaints, maybe just into a handbook, but wherever we put the rules for making complaints under Title VI, we've got to put it there.
Speed cameras, let's just be honest, folks don't seem to like them, so long and short of it, this is how it's going to work.
I don't like them.
Maybe you should drive slower. Nevertheless, here's how it's going to work. If you want to enter into a contract or you're renewing a contract, and it's not necessarily you all that's entering into the contract.
That's right.
It's your county, it's your law enforcement, and this company. You have to put this whether or not to enter into a contract up for a vote to your voters. And then if a majority of the folks vote in favor of it, congratulations, you can now have your contract, you can now have your speed cameras. There's a whole lot of specificity in this statute regarding how far the signs are supposed to be, what color the flashing lights are supposed to be, all of that stuff. What you need to know is if it's rejected by the voters, you have to wait 3 years before your county and law enforcement can bring this back up.
For most of you, this really isn't going to be the issue. This is your issue for county and cities.
But they blame you for it.
Whew. We are sorry. Those of you who attend these conferences know that we never, ever run over on time, okay? We did, but you see why. Let's take a break. Take till 10:35.
Ladies and gentlemen, please hold your seats for a minute. We have our sponsors going to come to stage and speak for a moment.
Thank you, I forgot.
Please welcome to the stage Adam Camacho, Education Manager of Evolve.
Hey, good morning and happy Monday. How's everybody feeling today? Yeah, awesome. I'm a little tired nonetheless, but coming to you from San Diego, I work with Evolve Technology. I am the Regional Education Manager, and I serve the United States, but specifically the 13 states on the West. And it's a pleasure to be here with you. These next couple days, we're downstairs. Come see us if you'd like. What we do is that we serve learning communities all over the world, really, and other establishments as well. But our focus is on keeping safe the places where we learn, live, work, and play. If you haven't seen us, have questions, I encourage you to come down. Essentially, we are a concealed weapons detection company, and we, like I said, I serve specifically learning communities in the United States. And it's a pleasure to be here with you. Again, thank you for all that you do, first and foremost. As a former 26-year veteran in K-12, 16 years of which I finished as a secondary administrator, it's the best work, and I applaud you for all that you do. Thank you for your time this morning.
Welcome back from the break. So we are coming back for the policy workshop. Just a reminder, check your badge. Make sure it says policy. If it does not say policy, you need to either go to the registration desk to change that, or you need to go elsewhere. Otherwise, you will not get credit, and we will ensure that everyone gets credit at the end of today's workshop. We'll do a scanning process using FeedLoop. A reminder, if you're a virtual attendee, we're tracking that you're online through the FeedLoop app. You don't need to do anything. We will ensure that you receive credit. Again, we want to thank our sponsors today, Evolve and Davenport and Company. In just a second, you'll hear from Davenport and Company. But just a reminder, too, that we will have an evaluation at the end of today's workshop. It's important that you fill that out. Okay, where is everyone? Y'all got to come back here. We have a lot more to get through before lunch. But I do want to welcome to the stage Davenport and Company. Thank you so much.
Most of you all are having some sort of food downstairs because I see a lot of empty chairs, but that's okay. I've been here since 8:30, and my head hurts, and I don't know how you all are going to do it because both Phil and Corey were extremely entertaining. There's a lot of information for a superintendent and board members, so first of all, thank you so much for basically focusing on what's most important here in Georgia and the resources, and that's the kids. And secondly, this is the first time we've sponsored this workshop. We are learning a lot, and we appreciate that too. So my name is Ricardo Cornejo. My colleague is Christopher Holt over there. We are with Davenport and Company. So what is that? We are a fiduciary municipal financial advisor. So what that means is that of our 115 clients here in the state of Georgia, and our other three team members who are not here, we focus on giving you independent and objective advice and putting your interest first. So we're not underwriters. We do not take a financial position. We do not buy debt, and we're not beholden to any bank. Basically, what we do is we focus on school districts on their budgets, their capital projects, their debt ability, their debt affordability, their debt capacity, because sometimes ESPLOS isn't enough. We do ESPLOS projections because we understand that every decision that you as board members and as superintendents make affect not only the children but the taxpayers. So for us, what we want to do, because your finance departments, God bless them, they're working hard to pay payroll, to keep the schools going. Sometimes what we feel is an independent review of the finance department. And when I say that, I mean take a look historically at your operations from basically your general fund and looking forward to see what's going on with that. Secondly, looking at debt capacity, debt affordability, and then your bond ratings, because we also do that. We also take care of doing bond transactions. In fact, just recently, we sold $100 million for Cherokee County schools. And half of that, or a portion of that, was refunding, which saved them over $4.1 million. We had over 10 underwriters bid on that. Again, let me say that again. 10 underwriters competitively bid on Cherokee County's bond issue. So with that, we hope that we have a chance to speak with you, especially at lunch, because I know that you all are taking a lot of notes here and trying to do and ingest everything that both Corey and Phil are giving you and information, and we're learning quite a bit. We hope to have a chance to visit with you, talk to you, and then and when we call on you later in the month or so forth, maybe you will have an opportunity to visit with us and see if there are some synergies of how we can help. And we look forward to that. And again, my next 2 minutes will be in Spanish for all those others of you. None? Okay, well then I won't do it that way. So again, we greatly appreciate it. Thank you so much for giving us the opportunity to do that. Phil?
Thank you, Ricardo, and thanks to our sponsors for adjusting with us as we dealt with our time constraints. We will, in the next hour and 5 minutes, make up and get you to lunch on time. That's our promise. Don't look at, oh, you didn't even bring it up here. Thank you, thank you. Don't look, if you saw Creighton's notebook that he had down here to prepare, you would think we will never finish. But we're going to make it.
That's just a prop, just a prop.
As most, this Creighton Lancaster, many of you know him, many of you don't. Creighton Lancaster and I are going to talk to you about an update on what's going on at the federal level. Now, if you pay attention to the news, you know nothing's going on in Washington. In any area. So this ought to be very fast, right? We ought to be able to get through it in a hurry. But we're going to see how that works. Number one is our chart that we developed a couple of years ago, 1.5 years ago now, when the president said in an executive order that only he interprets the law for the agencies, and everybody has to follow his interpretation. He's frankly told the Supreme Court that several times and had the Supreme Court disagree with him on that. So who is it that actually interprets the law? The courts, the administrative agencies, the president. We know one thing for sure, it's not Congress, because Congress isn't doing anything right now to speak of.
And Phil, they've created a little bit of a void with the administrative agencies as well by taking away Chevron deference from their rulings and rulemaking. So really, you're talking about the courts and the president filling the void of interpreting the law.
So let's talk about these 9 people and what they're going to deal with. Now, this is very intentional. Our goal, is to talk about transgenders issues for a few minutes and then move on, okay? But it's in the news. It's certainly in the courts. It's everywhere we turn, so we hardly can ignore it. And we'll get into more of this afternoon. It is very, from a lawyer's point of view, these transgender issues are fascinating because they combine First Amendment issues, free speech, freedom of religion, with 14th Amendment issues, due process, particularly equal protection, with Title IX issues, discrimination based on sex. So it's a complicated process, and we keep waiting on the Supreme Court to try to give us some definitive kind of guidance. Thus far, they haven't, but they've done a few things. So let's look at what they've done as a court. The Mirabelli versus Bonta case. This is a case that was decided by the Supreme Court using what they call the shadow docket. Sounds sinister, and some people think it is. But the shadow docket is in essence what the court uses at times when it needs to make a decision and doesn't want to put the case into the regular rotation where it will involve lots of briefs from lots of people, lots of arguments, and then lots of arguments among the justices about what to do. Generally, it gets on the shadow docket because a majority of the justices know what they're going to do, okay? And because there's some urgency, such as a pending appeal of a preliminary injunction or something like that, that needs a quick decision. You need to know where things are headed. Don't try to take any of this as the gospel. Unlike statutes, court interpretations change a lot, and we'll talk about that more after lunch. You want to talk about a little bit about the facts of this case?
Yeah, Mirabelli dealt with the question of, do parents have a right to know that their child is coming to school and positioning themselves as the opposite sex, appearing as a transgender student? And this is something counselors would always ask about. Do the parents have a right to know this? And in this particular case, the California Attorney General had issued an opinion that they don't have a right, and basically said schools should not disclose that status to the parents unless the child consents.
And it was really even more than that, because California had put this in statute. You know, this was a law in California. And as we all know, they do things a little different on that coast than we do on this coast, especially on the southern part of this coast. Nevertheless, that was their practice, and it was challenged, and the Ninth Circuit Court of Appeals reversed an injunction. The trial court had entered an injunction. And an injunction simply stays everything where it is, or whatever the court puts into place. And the trial court had put in place an injunction against this practice. The Ninth Circuit Court of Appeals reversed that injunction and said, no, you can't have this injunction. We're going to leave the practice in place. The United States Supreme Court said, no, we're reinstating that injunction. This is not a final decision on this case because it's at a very preliminary level. Having said that, it's pretty obvious how the justices are going to vote on this case, and it's not likely to change if the actual substantive appeal goes back up, which probably won't even happen given what the court has already done.
So, yeah, it's great guidance for us to know that you can't really shield that from parents just because the child is not granting you consent. One of the interesting things they did talk about in the case is there was no specific exception where the child believed or had shown that it would put them in danger if their parents were to know, and the Ninth Circuit Court of Appeals even acknowledged that that would be a reasonable step to take if the child could show a potential harm if the disclosure was made, and that would be a little bit of a different case.
The court said, the Supreme Court said to the Ninth Circuit that they did not properly consider Mahmoud. We've talked about Mahmoud earlier in other conferences. We're going to talk about it 3 or 4 or 5 times here, okay? Having said that, what's really important to me about this case is that it really emphasizes, as Creighton just said, parental rights. That is the buzzword that we're hearing everywhere, parental rights control. And we're not talking about parents having a right to participate in a meeting. We're actually talking about parents making decisions and deciding things with regard to this. Another case that is in the Supreme Court, not decided yet, should be any day, is Little v. Hickox. and also in the Ninth Circuit, but not out of California. So let's talk a little bit about what that case is all about.
Yeah, in this case, I think the state of Idaho enacted a ban that essentially required transgender males, females identifying as males, to compete in, or banning them from competing in female athletics. And they basically got into not accepting whether or not the child had, blocked puberty hormones and taken hormone therapy. That they weren't really concerned with that. And the Ninth Circuit really got into the science and said that their decisions and their law was not based on real science, that showed that basically once you went through those puberty blockers, you essentially were a female and should be allowed to compete. That was what the Ninth Circuit essentially concluded. And they concluded that the law was basically just for the purpose of having restrictions and preventing transgender females from competing against other females. And so the Ninth Circuit declared that law unconstitutional.
And obviously that was the purpose of the law, is to keep transgender female students and to require boys and girls sports teams to be separated by biological sex and not by any considerations of transgender or, as Creighton was saying, hormones or anything else. This case has gone to the Supreme Court. It's been argued before the Supreme Court. If you listen to the argument, good chance the students are going to lose, okay? Which is not a surprise to most of us that follow the court. The interesting part about this case is how far will the Supreme Court go in answering our ultimate question of whether Title IX applies based on biological sex or sex, preferred sex, if you will. How far are they going to go in taking this case as the vehicle to do that? Most folks think they're going to be as narrow as possible, but we'll have to see, and we'll be talking about this in the December conference. Very much related to this is a case out of West Virginia that was in fact argued with the Hickox case that asked the same question. It raises the issue that Creighton was just raising, because this particular student had determined to transition early in life and had stopped taking any, had blocked, not stopped, had blocked all male hormones since the 3rd grade. So her argument is, I'm no more a male than anybody else. I don't have testosterone. I don't have other male hormones. And so I ought to be allowed to, if I'm going to compete, I've got to compete as a female. And whether or not the court's going to make a difference. Here's the other distinction. The Fourth Circuit Court of Appeals split this case into 2 parts and said, only decided the Title IX claims. By the way, that they've consistently ruled that Title IX includes transgender and LGBTQ students. They were the first court to do that years and years ago now on a bathroom case. So they decided that. They did not decide the 14th Amendment case of whether they're entitled to equal protection under the law. So we've got a long ways to go to get some definitive answers.
And I think that case is important because the statute in that case is pretty close to the Georgia statute, the Riley-Gaines Act, that applied to transgender student participation in athletics in Georgia. So what the court decides in that case will be pretty helpful in deciding whether or not that will continue to be applicable.
And we will be, I will be surprised if the court makes any distinction in these 2 cases. I think it's going to decide the issue straight up, without distinguishing between these two particular cases. This is a case that demonstrates what we're getting a lot of these days in the transgender field, although it's a much more, this involves a statute in Colorado, and Colorado passed a statute that was designed to get at these camps and programs that will turn, or say they will turn, gay boys and lesbian girls into heterosexual, otherwise. They'll get them out of that. Unfortunately, their language was very broad, that they prohibited any practice or treatment designed to change or eliminate those behaviors. And this particular counselor, it's not really a school case. This particular counselor says, wait a minute, you're telling me in my therapy sessions, I can't talk to these kids about their options and what they might do and why they feel like they're gay or lesbian or want to transition. That interferes with my First Amendment right in the practice of my profession. And the court, by an 8-1 vote, rare to see in these kind of cases the court agree that much, agreed that the counselor's speech had been constrained based on viewpoint and therefore had to meet strict scrutiny under the law. If you don't know by now, when a court says you've got to meet strict scrutiny, you can't do that. I mean, it's virtually impossible to show the court that you've met strict scrutiny. So.
And they really found a good plaintiff in this case, because the counselor talked about kind of how she tried to kind of meet her patients with what they wanted and provided examples of how this is what the patients were coming to her and asking for. And this statute, in addition to violating her First Amendment rights, it was preventing her from providing the counseling that they wanted.
So this is a very complicated case, a lot of fun. I enjoy this case thoroughly as a lawyer. It don't do hardly anything to help you, okay? But it is from the 11th Circuit, which is our circuit. And it was petitioned for cert to the Supreme Court. And many of us thought they might take it for various reasons, but they didn't. So cert's been denied. This is a 3-panel court decision that literally with 3 judges, they have 4 decisions. You figure that out. Here's the way it works. The judge that wrote the majority opinion is one of the 2 majorities. The second majority opinion says clearly, I don't like any of this that's based on substantive due process. That's a 14th Amendment term that, frankly, has a long history in our litigation. It's much of the basis, not totally, that's too long of a rabbit hole to get down, but that talks a lot. The 14th Amendment substantive due process is important in such things as the abortion cases when they were decided, and in other such things. So this substantive due process, the second judge in the majority says, I don't like using this at all. I think we ought to do away with substantive due process, but I understand that I'm on a circuit court of appeals. I have to do what the Supreme Court says. They've told us that in substantive due process cases, there's not a claim unless the action of the school district or an employee shocks the conscience of the court. The example in the 11th Circuit that's most often given is a coach who literally took a lock on the end of a chain, swung it around their face, for their head, and hit a student in the face, putting out their eye. Okay?
So from the gas, that obviously shocks the conscience.
Yeah, that sounds like it shocks. And this case, much like the California case we looked at, involved a Florida situation where there wasn't a statute, but you had a student, 13 years old, coming to a counselor saying, I want to transition. And the counselor set up a group, if you will, to develop a plan to support the student. The student said, please don't tell my parents. Here's what all the bad things will happen if you do. And so they didn't. And because they didn't tell the parents, that's the case that went up. 2-1 decision in the 11th Circuit ruled in favor of the school district that this did not shock the conscience of the court. We'll see other cases as we go through the day that take this as a religion issue, other cases that take this as a Title IX issue, okay? But this was strictly a 14th Amendment case. The last decision was in dissent, 2-1. And the one said, do I have that? Yeah, I do. The one said in dissent, the right of parents to direct the upbringing of the children is among the unalienable rights for which the Declaration of Independence proclaims all men are endowed by their Creator. This is the other trend that we've been talking about, parental rights. This judge believes, or not only in the Constitution and the Declaration of Independence, and within what God provided all of us with, okay? 2 judges trying to stick to the substantive due process. One says, I wish we didn't have to deal with substantive due process, but if we do, I agree with the majority. The other judge wrote 2 decisions. One was the majority decision. The second was in response to, I don't want to do substantive due process. And she says, you've made this argument a bunch of times. Quit making the same argument. That's the law right now. That's what we've got to deal with. This case flies in the face of what Creighton said a few minutes ago about the California case. I wouldn't use it as precedent, but it's at least a case that says if the school system is trying to help this student, you know, in a way, and has some reason, that doesn't shock the conscience enough to create a constitutional claim.
One of the distinctions they made was they basically looked at what the counselor was relying on this case was a guidance document that was basically saying, you know, generally you develop the safety plan, you don't notify parents unless that's going to help the child. And they applied that guideline document and did not notify the parents. In the California case, which was actually decided after this one, they had a statute and an interpretation from the Attorney General, and so that was distinguishable based on this 11th Circuit opinion because they said the action taken by the administrators was executive action, whereas they would classify the statute as legislative action. And so you definitely don't want to adopt a policy, which would be analogous to legislative action, banning administrators or school teachers from notifying parents that they're going through these transitioning at school.
So what are the practical tips? None. We still do not have a decision on the constitutionality or, frankly, the Title IX rights for transgender students, and maybe even LGBTQ students more broadly. We'll see how that's going with the court. We'll see if we get that out of this session, out of the next few weeks, but it's probably unlikely. Until then, if you get one of these issues, do not do a knee-jerk reaction, and this is Creighton's point, and adopt some policy that says something that allegedly is going to apply to everybody. Let your school folks handle it like they handle all individual student issues, and figure out what's best for the student, what's best for their school. We do have some guidance. If they talk to their lawyer, which they need to do, then it can be worked out. And we've been lucky about not getting many cases out there that actually go to court, and we want to keep it that way until we get some definitive guidance. Legal decisions in this area, forget substantive due process, forget executive and legislative, whatever that all means, forget all those things. They're leaning towards protecting individual religious rights and individual parental rights. I can't tell you what the rule is, but I can tell you they're leaning that way, and we'll see more of that as we go along. I've already said, please avoid policies and stay out of the news. Please, 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 don't put it on your board agenda. Don't go on social media talking about it. Anything you can do to stay out of the spotlight in these issues is best for the school system. Okay, what about other Title IX claims, specifically Crowther? You want to talk about this for a second?
Yeah, this was actually two cases, and they both involved the University System of Georgia. One of them, Mr. Crowther, I'm not sure which university he was at, but he was an art teacher, and there was a Title IX complaint made against him, and he brought a claim based on how that was handled, alleging that his rights were violated through the investigative process.
You remember from earlier conferences, we've been talking about this for years. The Title IX procedures keep changing from one administration to the next on how much protection you provide to the alleged perpetrator. And that was him in this case, and he said, you didn't follow all the Title IX rules you're supposed to, and that hurt me in this situation.
And then the companion case was the Georgia Tech women's basketball coach. She wrote some letters complaining about how the men's team was getting better locker rooms, better finances. She had to spend all of her time going out doing fundraising, and alleged that she sent these complaints to the school administration and they retaliated against her. And so these cases came up and the question was posed whether or not Title IX provided a private cause of action for these two individuals alleging violations of their rights under Title IX where they were not complaining about violations of students' rights. And the 11th Circuit said they were without a claim under Title IX. They said this duplicates the rights they have under Title VII, and this was not intended by the funding legislation that enacted Title IX. And so their cases were thrown out. It's going up to the Supreme Court, though. They're going to issue a decision on that and decide whether or not the claim can proceed. The Supreme Court had previously held that staff members complaining about students' rights being violated did have a claim for retaliation.
Which may be the Georgia Tech case. One thing you just need to know, because it's important, GSBA has been asked by the National School Attorneys Association to join, that is, let's sign off on a brief to the Supreme Court asking the court to take this case to show that Title IX should not include individual employment claims, because those are covered under Title VII. That's the EEOC, that's that process. We don't need an overlapping, confusing process for those kind of claims involving individual discrimination. Number one, we'll see if they even take the case. Number two, we'll see how they decide it. But you need to know what the status of that is.
And another big benefit, if you don't recognize that independent Title IX claim, is the Title VII. You have to basically file a charge of discrimination with the EEOC within a certain amount of time, whereas you can wait for 2 years under Title IX to bring your case, and so it kind of cuts down on some of that.
It's really hard to know whether this is going to require you to change your Title IX policies. Why do I say that? Because unless the Supreme Court makes clear that Title IX doesn't cover any employment claims, period, then employees will stay as one of the groups under Title IX that is protected, just not for every single claim. So we may have to put clarifying language in or not. The other question is this. Who knows these days what OCR is going to do? But previous OCRs have said, we don't care what the courts say. We're going to interpret Title IX our way for enforcement purposes. Thus, you've had to have policies that address Title OCR's interpretation. So we got a long way to go before we know what's going to happen with this and how we're to respond to it. Right now, you're fine with what you have. Just be on the lookout for this particular case and how it moves forward. All right, let's have a moment of silence or prayer before we proceed to this next. I mean, you think LGBTQ issues are complicated. Just wait till you get into religion issues. We will talk about Mahmoud several times. We will talk about it in great depth after lunch. For right now, we're going to talk about it just to make you aware of what the Supreme Court has done in the last year dealing with this. In Mahmoud, you see that the question posed was whether or not public schools burden parents' exercise of religious rights when they compel elementary school students, both of those things are important, elementary students and parents, to participate in instruction based on gender and sexuality when their parents' religious convictions are against that and the school doesn't provide an opt-out. So, what happened in Mahmoud?
The court said that this was a violation of the parents' First Amendment rights. Originally, when the school district was providing these particular texts, and these were bills that normalized LGBTQ plus relationships with celebrations of weddings and celebrations of things like that, and the parents originally were given an opt-out, but eventually the school took that away, said it was too inconvenient, and they...
Lesson number one, never give parents or students something that you then take away down the road. Get you in trouble every time, and that's what happened here.
Yeah, and they had these 5 storybooks. They gave some general guidance. You can put them on the shelves, you can recommend them to students, you can offer them in book clubs, or you can use them in class to read aloud. The school district provided guidance to teachers about how they should incorporate those into the curriculum, and including encouragement to disrupt the thinking of their students.
And
so that was the intended purpose.
That is the language that the court, the majority of the justices really harped on, that the whole purpose of this curriculum was not just to have these books available, but was to in some way indoctrinate, disrupt the thinking of their children so that they understood or believed that it was all right for men to marry men, women to marry women, etc. I mean, that language really bothered the court, and that's why they talked about they were disrupting the students' thought process.
And so what accommodation did the school district offer when parents complained? And there were complaints from like all religions. This was like widely disliked. There was a lot of people speaking at board meetings along those things. And the accommodation they offered was, if you don't like your child participating in this, they can stay home when we're going to use the text. However, they're going to get an unexcused, there will not be an excused absence.
You may remember several years ago, some of you tried to use that argument when parents wanted to opt out of required mandated testing, okay? If you don't want your child to be tested, just leave them home that day, okay? That didn't work either very well, by the way, but that's the kind of argument that they first made. Then they just gave up. The school support said, we can't do this. We got too many people opting out. Teacher can't keep up with which groups she has, who's opting in, who's opting out. Forget it. Nobody can opt out at all. That's when the problem arose. That's when the lawsuit was filed.
But they did one thing right. They still allowed an opt-out for the sex education program, which we would have to do here in Georgia.
Because they had a state statute there, very similar. So the parents sued. They wanted an injunction, not just a preliminary one, but a permanent one. They wanted the injunction to stop the school board from not allowing them to opt out, at least, if they were going to require these books to be read, etc. The district court said no, it's unreasonable for the school to have to make all these exceptions for everything. Fourth Circuit Court of Appeals affirmed and agreed with the district court. The Supreme Court did not. And here's some of the principles that are in the majority decision. Don't worry too much about the, read these for the big picture, not for the little details, if you will. We've long recognized the rights of parents to direct the religious upbringing of their children. I don't think anybody argues with that proposition, okay? We've held that those rights are violated by government policies that substantially interfere. Those are the two words at issue. Substantially interfere with the religious development of children. And that is a violation of the parents' free exercise rights under the Constitution. And there's this Wisconsin versus Yoder case where the Amish had a practice where they wanted their children not to have to come to school after the 8th grade. And the state had a compulsory attendance law, much like we do. And the Supreme Court said you can't force them to violate their religious beliefs to send their children to school after the 8th grade. And the court equated that issue, that fact situation, with the one you had in Mahmoud. And that's the same thing. It substantially interferes, as it said. One of the things the court emphasized, and that we've talked about in previous sessions, there's no federal right to a public education. But once Georgia or any other state grants a right to education, then it can't discriminate based on an unconstitutional provision. And it can't condition the grant of that right, the grant of that benefit, based on a willingness to surrender your religiously impelled status. I'm sure Creighton knew this already. I kept reading that. Finally had to look up what the word impelled means, because I kept envisioning this as impaled. And I thought, what? Religiously impaled? I mean, that sounds medieval to me in some ways, but obviously impelled doesn't mean that. And if you don't know what it means, look it up. That's what my mom always told me. So it does make sense once you know what it means. Public education is public benefit, and so it can't be conditioned upon the parents' willingness to surrender part of their religious exercise and belief. And that's what the court says happened here. All right, we're going to talk about this a lot more after lunch, so we're going to do this fairly quickly. But here's the legal issue for all of us. The court says, under our precedents, the government's free to place incidental burdens. So is this an incidental burden or a substantial burden? Where does this fall? As long as it's a neutral policy. In most circumstances, there are two questions. If the burdensome policy is neutral, generally applicable, it's fine. If the first question can be answered in the negative, a court will proceed to ask whether the policy can survive strict scrutiny. We've already answered that. Strict scrutiny, no, you lose, okay? So they talk so much about Yoder that they say this burden is just like the one of the Amish in Yoder. And once you get to that point, you know where they're going. No doubt about what the court's going to do. The board's policies, like the compulsory attendance law, substantially interferes. The court answers that. It's not a minimal, it's substantial interference, and pose a very real threat of undermining the religious beliefs and practices of the parents who wish to educate and raise their children in a certain way. It says that strict scrutiny has to involve interest of the highest order, and that's what this is, according to the Supreme Court. They specifically address the argument that the court makes, the board makes, that we've got to deal with lots of kids, lots of situations. How do we let them opt out of whatever they want to?
And the issue was they had already shown they could facilitate the opt-out. And so to the degree they're basically saying it's too hard to do the opt-out for these particular books, the argument fails because they're already shown we're able to do it for these other areas. And so you can't really survive strict scrutiny when you're actually doing what you're trying to avoid somewhere else.
One of the issues that they never really fully discussed was in the other cases, sex education, for instance, you're opting out of an entire class or an entire unit of instruction. You're not opting out of a particular subject matter in one room, which is the issue here in Mahmoud. But Creighton's right. They said you opt out for all kinds of reasons. You make all kinds of individual accommodations. Why can't you do it here? They call it a robust system of exceptions. And that undermines their contention that they can't deal with opt-outs. And they acknowledge, this is an interesting sentence for all of you who deal with courts and don't like the decisions they make. Whether you like this one or not, it's not the issue. Courts are not school boards or legislatures. They're ill-equipped to determine the necessity of discrete aspects of the state's program of compulsory education. So it must be emphasized that what the parents here seek is not the right to micromanage the curriculum, but rather to have their children opt out of a particular educational requirement that burdens their well-established right to direct religious upbringing. We express no opinion on the educational value of the board's proposed curriculum, other than to state it places an unconstitutional burden on these parents. Providing such an opportunity, the opt-out would give the parents providing the opportunity without an opt-out would give the parents no substantive control. Let me just start over with that whole thing.
So the court's trying to say, directing school curriculum's really important. That's a specialized job for school administrators and school boards. We're not going to interfere with that, except in this case. But it really opens Pandora's box to a lot of things that could happen. Because when you talk about what is a sincerely held religious belief, most attorneys look at each other and it's like, I don't want to really question whether or not someone has a sincerely held religious belief if they say they have it, no matter how crazy it is. So then, how far can parents go in opting out of whatever particular school curriculum they happen to believe according to their own individualized, sincerely held religious belief is going to indoctrinate their child against their belief? It's really opening Pandora's box for the next argument, and we don't know where that will take the court.
And that's much of what the dissent says. I'm not going to read these slides to you. Again, you have them. This is an important quote. Whether you believe it or not, this is the other argument, the other policy argument, that the ruling threatens the essence of public education. If you're going to allow parents to make these kind of discrete, individualized decisions, then where's the public in public education? All right, this is a fairly easy case. The Florida High School Association, like the Georgia High School Association, has private schools and public schools. At the state championship game, one of the religious schools wanted to give an invocation over the loudspeaker. The association said, no, we're responsible as a state actor. Under the law, we can't do that. And the 11th Circuit ultimately ruled against the school's request to have a prayer on the public speaker.
Yeah, the interesting thing in that case is it was two private Christian schools who were playing for the state championship, and they essentially argued this is a religious event, and they said, no, Florida High School Athletic Association event, they control it, they're a public actor, and as Phil said, they've got a big script, they got to acknowledge all their sponsors, and we can't really throw in a prayer in there without violating the First Amendment.
Some of you remember the other religion cases we've talked about previously, where the courts have ruled that even religious schools can participate in certain public benefits, because to deny them that would be a denial of their First Amendment freedom of religion rights. This is different because nobody could pray. It wasn't like we were allowing some groups to pray and some groups not. And this is the first time I will say this out of probably 20 the rest of the day. First Amendment claims are very, very fact-specific, always very fact-specific. Hard to make hard and fast rules. Our present administration has put out its guidance on religion. This is something that administrations are directed to do to comply with what I still call No Child Left Behind, but whatever it is, that you have to certify as a superintendent and a school system that you're not interfering with any student's right to voluntary prayer. And part of the regulation that says that talks about the department issuing guidance as to what that means. This is here because this enhances what was in the law previously about individuals having a right to complain that the school system is interfering with their rights to pray. Previously, we had that in the law, but not to the extent we were going to have reports on it, etc. So you may be seeing more of these complaints that you have to deal with and that may have to be appealed to the State Department of Education. You will also notice, if you want to read what I'll call the Trump religious guidance from that Department of Education with the Biden religious guidance, they both end up in the same place, sort of, but they really emphasize different things. And so it's really important to think about, what the guidance means. This is more of an effect on signing that certification. And if I'm the superintendent, I'm going to want to know and make sure we're not doing any of this before I sign off on that certification. So hopefully nobody has school board policies about prayer in schools or religion. If you do, you don't need to have them. It's a dangerous area to start trying to write policies in. Different groups have read this guidance, just as they have guidance from previous presidents, and interpreted it different ways. This particular guidance really emphasizes Mahmoud that we just talked about, and emphasizes the Kennedy Bremerton, which is the coach praying on the field at the end of a game, okay? One more time. Talk to your attorney anytime you have one of these, and know all the facts when you do, so you can make reasonable decisions. One social media case that we can briefly talk about involves a university student.
Yeah, in this case, you had a University of Florida law student who was pretty close to graduating, and he had some run-ins at the school with people with violence and threats, or getting close to threats. And he went off campus and made a post on X, and he said, "Jews must be abolished by any means necessary." So who thinks that sounds like a threat? It sounds like a threat to me. And the court said, students, they went into the case of the cursing cheerleader and kind of looking, do we have jurisdiction here? And they kind of distinguished it because, one, it was a threat, unlike the cursing cheerleader who just kind of expressed her disdain for the person who cut her from the cheerleading team. Two, they were able to show that there was a disruption at the school. They were able to show that other students were aware of this particular student's violent nature, that they were afraid of him, those types of facts that led them to conclude this was a threat, and they actually ended up kicking him out of school, and the 11th Circuit found that that did not violate his First Amendment rights based on the nature of the threat and based on the disruption. So the question is, what happens if this happens in your school? Do we reach the same result? Well, obviously, we can say that this is a threat. Is it a terroristic threat? It would be a felony, because in Georgia, we're dealing with off-campus misconduct. To have jurisdiction, we've got to have a felony, and we've got to show a nexus to the school environment. The facts of this case show that there was a nexus to the school environment, because the other children, or law school students were afraid of this person. And so I think if you have those facts, you've got the nexus. The question is whether or not
you've got jurisdiction.
You've got a felony. And I'm not positive that that would rise to the level of a terroristic threat, because that
which leads to the second question. Could you do nothing? And one of the main, and we'll talk about this later, but one of the main threads of what the OCR is doing these days is dealing with threats against Jews and anti-Semitic threats. That's an oxymoron, but in any event. And so you do have the possibility that if the school does nothing, then some of the Jewish students could claim a hostile environment, a Title VI violation in some way. You still have the problem of being off campus, but it's a complicated balancing act, obviously, that you have to deal with.
Yeah, I would want to write a letter to those students saying, if anything happens to you that you feel like he's doing anything to you at school, if you're not taking disciplinary action, bring it to this person and name that person. Give them someone to bring that to.
Website compliance rule that most of you didn't even know was coming up has been extended for a year. That's a good thing. Some of you went through this in earlier administrations. Now you have a little different set of rules that apply. It's really important that you know whether your website, it's not important that you as a board knows, it's important that you as a board ask your superintendent and y'all are aware that your websites are in compliance or you're getting them in compliance in case you were to have an OCR investigation. This is a special ed case coming out of Georgia. It has a good ruling, ultimately, that a kid moved from one special education setting, resource, to another special education session, self-contained. That's not a change in least restrictive environment, okay? The case lasted so long, though, that the students stayed put. They started in the 4th grade. He finally graduated by the time the 11th Circuit ruled on this case. So who won this case?
Mom and Dad.
We got the right decision, the school got the right decision, a good decision for the rest of us. The kid and the parents won what they wanted as well.
We'll get the next one, right?
But listen, listen, listen. You have very little role to play in special education cases. That's in the hands of an IEP committee, especially if you have a lot of them that are involving a lot of money. You do have the right to ask questions of your superintendent and special education director. How are we approaching these issues broadly to ensure that we're doing the most effective cost-benefit analysis? Special education cases, as you've heard me say from this podium before, are the domestic relations cases of school law, okay? And once you get a case, you've still got to deal with that student and that parent as long as they're there. So there's got to be some balancing of what are we fighting over, is it worth it, and can we win, and when we win, have we won? To analyze those cases particularly. This case is on here only because some of you will remember that our state is also in a suit about its GNETS programs, right? The US DOJ was investigating Florida's placements it took them over a decade, and they were litigating over a decade about what to do with children that had medically complex conditions that were at risk of some kind of institutionalization. The 11th Circuit affirmed the injunction below. There's little minor changes, but basically affirmed the injunction below that the state violated the ADA. They failed to provide care in the most integrated setting, that's sort of like the least restrictive environment under the ADA setting possible. They failed to avoid institutionalization. That happened way too much. The kids got institutionalized. Their planning made it difficult for students to return home. So in all these ways, the 11th Circuit said they failed. These are some of the same issues, not quite at that level of institutionalization, but close, of transitioning kids back from GNETs to the regular program that DOJ has threatened Georgia and has sued Georgia over about its GNETs program. So that's why we give you this case. Real quickly, what is happening at the US DOE OCR? It would be nice to know. Here's what we know. They are spending a lot of time investigating transgender student policies that they hear about, and if they hear you've got one, they go after you. Unfortunately, in Georgia, most of you don't have one, and so they're going to leave us alone generally on that issue, unless you make the news somehow. They're spending much less time in dealing with Section 504 and traditional civil rights claims. When this slide was written several weeks ago, there had been no findings by OCR as to race discrimination under Title VI in a year and a half involving students of color. Okay? There had been findings, at least one, involving white students, a white student. The focus of the department is on dismantling the department. The workforce has been cut in half. That's been rolled back a little bit. In fact, it's gone back and forth so much that I don't think anybody can figure out who works where right now. Department of Labor, at least that building, has taken over a lot of the folks. Regional offices have been closed, not the one in Atlanta. We still have that one open. Often there's pursuit of very targeted investigations where from the outside it looks like OCR knows what it wants to do and they're going in to do it without much of an investigation going on at all. There is a perception, whether it's reality or not, of chaos operating within the office right now. We'll see how that plays out in the rest of the administration. We still have 2.5 years to go to see how that might work itself out. So that's what is generally happening. Here's your practical tips. Stay off the radar screen. Just please stay below the radar. Anything you can do to do that. And expect parents, especially in 504 cases, they're going to find workarounds. One of those workarounds is going to be filing State Department complaints with the State Department of Education, okay? And so they're going to find some way to get their complaint in front of somebody else to hear it.
And they're using artificial intelligence to draft their complaints in many cases, and they can turn out a 20-page complaint in 5 minutes.
And somehow we can't do the same to provide an answer, right? It doesn't work that way. All right, Stephanie's going to come up. Don't leave. You'll miss lunch if you do. Stephanie's going to come up and explain what the procedures are for lunch and when to come back.
Thank you.
All right, folks, welcome back. Those of you who are back, you're late. Those of you who aren't, you'll need to sign in on the late sheet up here, up front. And you'll need to get permission from your homeroom teacher. All right, we're going to move on because I am assuming, since we are in Savannah, some of you have other plans after this conference is over. And more than one of you has plans after this conference is over. and we're going to try to get you to those plans as rapidly as we can. All right? Before we start this presentation, and while the rest of the crowd is coming in, let me tell you about a case quickly that I just forgot to put on the other slide, okay? And it's an important case, and I'll tell you why. The case is Louisiana versus Callais, C-A-L-L-A-I-S. I assume you can spell Louisiana. It's a case that the Supreme Court decided dealing with the Voting Rights Act. And many of you may have followed the case. It made a good bit of press. It was in the news a good bit. And so you may know a little bit about it. The Voting Rights Act was enacted, 60 years ago, 60-something years ago now, in an effort to provide some equality of representation for minority and underrepresented populations. Over the years, the Supreme Court, and philosophically this is what we're going to be talking about, but not specifically, the Supreme Court has gradually whittled away at the protections of the Voting Rights Act in many ways. And the Louisiana case was one such situation. Why does it matter to us? Because we're fixing to have a special session of the General Assembly, the purpose of which is to redraw districts, congressional districts, Senate districts, and House districts at the state level. Okay? That usually only happens every 10 years after the census is completed and we have documentation. This Louisiana case is the reason it's happening now. In my opinion, it's fortunate, and I think many people would agree with me, that we did not rush to do it before the election, which is what many red states with red general assemblies and governors did. So it's not going to matter as to this election, but it will matter as to future elections. More important to me, what I'm fixing to tell you will matter when you get around to redistricting the districts for your Board of Education. Usually, almost always, there's few exceptions in the room, that is done with the cooperation and work of your local legislators and the State Office of Reapportionment, of Legislative Reapportionment. Some of you probably had the experience, I've done it many a times, of sitting at a computer and drawing the lines on the computer and saying, if we did it this way, here's what would happen, and blah, blah, blah. In the past, one of the issues that we have been most concerned about is ensuring that in Georgia, it's primarily black, but frankly, in some of our communities, it's Hispanic populations are represented by having districts from which they can select a representative of their choice. And many times we have had boards of education draw districts to try to make sure there was at least one African American on. It's really not ensuring that they're on the board, it's ensuring that you're drawing a district that represents their interest from which they will elect somebody to the board, okay? And sometimes you try to draw two, etc. All right. The Callais case said the following. It dealt with a Louisiana's attempt to add a black district. and the Supreme Court said it was unconstitutional, and that the Voting Rights Act, as interpreted wrongly, according to the court for 60 years, as interpreted by many folks, the Voting Rights Act was not a good enough reason to justify an unconstitutional drawing. Why was it unconstitutional? Because it intentionally used race as a factor in drawing the districts. And it should be, according to the court, race neutral, totally. What does that leave of the Voting Rights Act? Very little, very candidly. It is still a violation of the law, not only the Voting Rights Act, but the 11th Amendment, to intentionally use race one way or the other, so that if districts were drawn and could be proven to specifically exclude black representation, that would be a violation of the 14th Amendment and allegedly Section 2 of the Voting Rights Act as well. But proving that has to prove intent. With our politics in Georgia and otherwise being so partisan and divided so that the Democratic Party tends to represent more minority citizens. The Republican Party tends to represent more majority citizens. The excuse given by those drawing the maps is, we just want a partisan advantage. We want to win. Excuse me while I turn this off. We want to win, so we want districts that will give us an advantage as Republicans. Has nothing to do with race. Has to do with how people are going to vote. Okay? That's the story. But I tell you that because it's going to be a big issue for you. And I urge you to watch, and by watch I mean read primarily, but pay attention to what happens in the General Assembly and how they talk about these issues. They're going to come home to you at least after the next census, maybe even sooner. All right, clear the decks. Start over. Beth Kinsinger is up here with me. We're going to do something a little different. So let me introduce this topic and make sure you know what we're trying to accomplish. Because I'm sure there are times you sit out there and say, what in the heck are they talking about? Why did they use that example? All right, here's the deal. The First Amendment has become, it's sort of always been this way. It's not like it just happened overnight, but really has become in recent years a vehicle for making a lot of different arguments, such as in the Mahmoud case that we'll talk about in a minute, and we talked about in the second session, where sort of used to say the religious beliefs and religious rights of the parents were being violated in this case where there was not an opt-out for this curriculum, okay? All right. We want to talk about the First Amendment and its development in the courts, especially the Supreme Court. We want to talk about it because we want you to understand. I was talking to Michael or somebody during the break. We thought we used to understand what parts of the First Amendment meant. These days, many of us don't have a clue what they mean anymore. And we want to take you through where the court was not that long ago and where they sort of are now, to give you a sense of what's going on so you can recognize the issues as they come up. All right, with that, this is somebody's cute, Brian's probably, or maybe it was Zeus's. must be precedent to win. And we don't know if that's true anymore. We're not sure you have to have any precedent to win. Over 250 years of the country and the Supreme Court, there's been a dramatic swings back and forth in how the court interprets critical parts of the Constitution. In recent years, there's been confusion, specifically about such basic principles as the First and 14th Amendment, how they should be interpreted and applied. Now, what effect does this have on you and on school policies and on serving on a school board? What should we anticipate in the near-term future? I'm not about to look 10 years ahead, but what should we anticipate in the next few years as we deal with some of these issues? Okay, here's the First Amendment. If you haven't read it in a while, I urge you to read it. It's short, sweet, to the point. In one of these cases, one of the justices makes the point, it's only one sentence. Well, it's sort of a run-on sentence if you want to know the truth, but so be it. Congress shall make no law respecting an establishment of religion, prohibiting the free exercise thereof, abridging the freedom of speech or of press, the right to assemble, to petition the government. And historically, we've sort of taken those elements and pieced them out, you know?
Absolutely.
As separate entities, if you will, right? You're seeing this court, particularly, more and more sort of grab them together. And they'll talk about the due process clause in one paragraph, free speech in the next one, freedom of religion in the next one, without really making a clear distinction on where they're going. So, once again, establishment of religion, prohibiting free exercise thereof, abridging the freedom of speech. Now, here's the 14th Amendment, relevant parts. Nor shall any state deprive any person of life, liberty, or property without due process of law. If you want to know what due process of law means, in the old days, Beth, in the old days, we actually had in what we called a library. Any of you remember what a library was? In our library, we had, among many, many other things, a set of the United States Code annotated, which means it gave us all the cases on particular statutes, particular provisions. If I remember the last time I saw one, the books on due process took up about 6 volumes in those annotations, okay? And of course, the other one is equal protection under the law, which is not quite as difficult to understand, but certainly has, in our neck of the woods, had its own share of issues. All right, move on, Philip. Get out. Just go. All right. So we're going to step back to 1971. Beth is going to tell us a little bit about what Libman v. Kurtzman is all about, and then we're going to talk about why we care.
Right, so this was one of the first really big Supreme Court decisions examining the First Amendment and in the context of particularly the Establishment Clause. That's what this court focused on. And this involved an interpretation of 2 statutes. One was from Pennsylvania, one was from Rhode Island. And these were really funding statutes that provided government money that went to fund the salaries or materials for teachers, but not just your traditional public school teachers, but also teachers in religious schools. So the question became, can we use these government dollars to fund religious education?
The point is made on the slide for those Baptists in the back row who maybe can't see that far, or for those older people in the front row that maybe can't see that far. I emphasize the point that this opinion was written by Chief Justice Warren Burger. No more conservative justice could possibly be found, okay? And he's a Nixon appointee, and the court decision was unanimous. So when this decision came down, everybody sort of thought, okay, this is what the Establishment Clause test is going to be. So let's look at what the court said.
Yeah, so the court made what became known as the Lemon Test, and it basically looked at 3 different questions that had to be asked when you were going to analyze something as whether it was a violation of the Establishment Clause or not. First, you've got to look at, did that statute have a secular purpose? So on its face, looking at it, does it have a secular purpose? And they're also going to go back and look at the history of that statute and when it was developed, and why was that statute developed. Second, the principal or primary effect must be one that neither advances nor inhibits religion. And then finally, the one that probably gets the most talk about a lot is the whether there is an excessive entanglement with the government and religion. And that's a lot of what the court, in deciding the Lemon case, looked at, that excessive entanglement with those funding dollars going into the religious instruction context.
And that's, those 3 questions sort of became the framework under which the Establishment Clause of the First Amendment was to be analyzed and to be decided for years. The court goes on to say the language of the Religion Clause is at best opaque. Yes, especially now, particularly when compared with other portions of the amendments. Its authors, and this becomes sort of important, well, very important, frankly, it's not just that they prohibited the establishment of a state church like the Baptist Church in Georgia, the Episcopal Church in Massachusetts, whatever. It's not like they just, the Puritan Church would be a more better example years ago. It's not just like they prohibited a state church like England has. They prohibited any law respecting an establishment of religion. Obviously, the court at this point in time thought that that was a fairly broad definition, law respecting an establishment of religion. Then, years and years later, we come to a case called Espinoza v. Montana Department of Revenue. The Chief Justice at this point in time, we've been through several by this time, but at this point in time is John Roberts. Chief Justice Roberts wrote this decision, and it was not a unanimous decision. It was a 5-4 decision. So we want to look at a little bit about why and what may have changed in this process that you need to be aware of. Tell us about Espinoza.
All right, so this was a case that came out of Montana, and there the state legislature enacted some tax credits that could be utilized for scholarships. Ultimately, the money was going to go to scholarships for families to use for the education of their students.
Does that sound familiar? It ought to. It's exactly what Georgia has now.
And then the Montana Department of Revenue said, wait a minute, we want to make sure that our government isn't funding religious education, so parents, you're not going to be able to use this scholarship funding if your child is going to a religious school. So a couple families got together that said, you know, look, we really want our children to go to this private Christian school. That's in line with our beliefs. Government, we think you're infringing on our rights by telling us that we can't utilize these scholarship dollars that are available to all other students.
The plaintiffs were basically low-income mothers. In these kind of cases, it's not like the clients pick the lawyers and the cases. it's like the lawyers and the interest group find the plaintiffs that they can use most effectively. So these were low-income mothers who wanted to send their children to Stillwater, but couldn't afford to do so unless they got these scholarships. It met all the statutory criteria for, like every other private school, and petitioners chose it in large part, and explicitly they said this, because it will teach the same Christian values that we teach at home. We'll get to how that sounds familiar to you in just a minute, okay? The free exercise clause, now wait a minute, I thought we were talking about the establishment clause.
Right.
I mean, so all of a sudden, the establishment clause, which has to do with this entanglement and whether or not the state and religion are too excessively entangled, by this time, when Chief Justice Roberts is writing, we don't talk about the Establishment Clause anymore. Now we're talking about the Free Exercise Clause, which applies to states because of the 14th Amendment. We won't even get into that. Protects religious observers. Those aren't people that just look. Those are people that actually do religion, if you will, against unequal treatment and against laws that impose special disabilities on the basis of religious status. The court says it's long held this position. That depends on how far back
It's 40 years long.
Lemon, you know, and other things. So it said the free exercise clause protects against even indirect coercion, and a state punishes the free exercise by qualifying the religious from government aid, as Montana did here. It's not a matter of which case is right or wrong. That's not at all my position. I don't have a position on that. Lawyers are good. We can make an argument on this hand or on this hand. You know, that's part of why we went to law school. And Beth and I could stand up here and argue either one of these cases, and then when the bell rings, we could change sides and argue it the other way. So I'm not advocating for either case. I'm simply making the point that we've had a dramatic change from the Lemon test, where we were talking about giving money to schools or students, I forget now.
Schools. Well, teachers' salaries.
Teacher salaries, for teacher salaries, so indirectly to individuals. And Espinoza, where we're giving money through tax credits, again, sort of indirectly, to parents to use as they want to. And we've changed from the Establishment Clause to the Free Exercise Clause. Now, if you followed us that far, you're way ahead of the game, okay? But we're going to take it a few steps further here. Espinoza treated specifically, they said these folks are members of the community and their exclusion is, and you know, look at the language, folks. It is really important to look at the language. The language in Lemon talks about, and I'll go back and find it. The language in Lemon talks about that, well, not there, that it was confusing. Is it best opaque? Okay? And it talks about how you've got to balance certain things and ask these three questions. In Espinoza, by this time of 2018, the court is saying that it is, one more, whoops. come on. It is odious to our Constitution and cannot stand that members of this religious school cannot take part in receiving this government state tax money from Montana under the same program as other folks. If you don't see that, again, right or wrong, you may think Berger's decision was terrible. It doesn't really matter. It's a matter of looking at how far things have changed and how we're looking at things so differently now. So what are the ramifications of that in the school setting? I will tell you that when I first started law, 2 or 3 centuries ago, the Establishment Clause was certainly the boogie bear, certainly the thing we all worried about in terms of school violations. We wanted to make sure that our schools did nothing that seemed to be an endorsement of religion in any way. And we were often fighting over relatively silly things like the sign that the cheerleaders ran through, that had a Bible verse on it that nobody had ever heard of, okay? But it was from the Bible. And we were arguing over whether that was an establishment because these were cheerleaders at the school, etc. So the ramifications are pretty strong that now we look much more carefully, not at the Establishment Clause end of things, but at the free exercise end. Are we letting everybody, regardless of their religious beliefs, act in the same way and have the same benefits and have the same privileges?
Yeah, it's really a shift between looking at what the government is doing, what you as schools and school districts are doing under that Establishment Clause question, to how is the individual impacted, and what rights do those individuals have, and is their free exercise being impeded? So it's a real shift in the analysis and the focus of where the questions are going to be.
Now, once again, this is a case that was decided not too many years ago at all, and that we talked about here in this conference at some length. But we're going to talk about the case again, not just to rehash and remind you of the case, but to talk about how it fits into this movement that's taken place and that you're having to deal with and figure out where we are on the continuum with any given matter that you deal with. This was a decision by Justice Gorsuch. Many of you will remember Justice Gorsuch was the first Supreme Court justice appointed by President Trump. It was a 6-3 decision, not unanimous. And we'll talk a little bit. We've talked about the facts some. You'll see more of the facts, but let's talk about what the court itself said about the analysis. This is the case, as you may remember, that the District Court and the Ninth Circuit Court of Appeals both ruled in favor of the school district that to allow Coach Kennedy to kneel on the 50-yard line immediately after a football game. I'll always ask if he was pointed towards Athens or Tuscaloosa, But in any event, to kneel on the 50-yard line was to not allow that, to prohibit that, was a violation of the his free exercise clause. And the Supreme Court disagreed with that by a 6-3 vote and said what the lower courts overlooked is that the shortcomings associated with the Lemon test, the one we were just talking about, is it's a historical approach. I think that means non-historical, but I'm not an English major, to the Establishment Clause. And that became apparent, so apparent, that this court long ago abandoned Lemon and its endorsement test offshoot. Now, Beth, I don't know how many First Amendment cases you've read that were written since Lemon. There's not a one of them that overrules Lemon.
Right.
Okay? And yes, there are judges that were justices and judges that were very, very critical of the Lemon test. But it was more a matter of getting around it, ignoring it, explaining why it didn't apply, explaining how we're going to interpret it. And where does that leave you? What are we supposed to do with that? We don't have any kind of test, you know. Lemon wasn't great, but at least we had something. So where are we now? And this is what the court said. In the place of Lemon and the endorsement test, this court has instructed that the Establishment Clause must be interpreted. Now, we're talking about the Establishment Clause. Why? Because the school district said that to let Kennedy pray on the 50-yard line as a football coach might lead folks to believe they were endorsing, the school district was endorsing a religion, and that would violate the Establishment Clause. And 1, 2, 3, 4, 5, 6, 7, 8 judges agreed with them. But 6 did not, and they were the ones that counted on the Supreme Court. So in place of the Lemon test, this court has instructed that the Establishment Clause must be interpreted by reference to historical practices and understandings. Now, that's a lot clearer test, right, Elizabeth?
Perhaps I disagree with that.
So, obviously, you've heard that many justices on the Supreme Court look back and want to try to interpret the Constitution by its literal language based on how it was written and what it meant at the time. I'll make a sacrilegious and dangerous analogy, but heck, this is the last summer conference I'm doing, so why not? But it's much like folks that say you have to read the Bible literally to interpret whatever it may mean. And immediately you start running into problems. Wait a minute, do you really mean this is literal, et cetera, et cetera? Okay, how does this affect school districts? Well, let me just ask. Did we even have public schools when the Constitution was written?
Nope.
Did we have cheerleaders, coaches? You know? So trying to interpret and apply a historical test in an era so different from what we're doing now and what you're doing now is not any easier, I would say, than trying to apply the 3-part Lemon test. Okay, that brings us back a little bit. Let's step back to Santa Fe versus Doe. This was a decision 26 years ago now by Justice Stevens, even though appointed by a Republican president, one of the so-called liberals on the court at this point in time. It was a 6-3 decision, and Santa Fe involved the issue of football. When you're talking about football and prayer, you're talking about a dangerous combination. So, while the suit was pending, the district adopted a new policy. Well, go back to the first part. Somehow these got out of order in the way they did. Prior to the lawsuit, how did they handle prayer at football games in Santa Fe?
So this school district really had a history of having a prayer before each football game. And it was traditionally delivered by a student chaplain. And it was definitely religious in nature. So in the course of this lawsuit, the school district, I guess, thought, well, maybe this isn't going to go our way. Let's try something new. We're going to have a vote, and we're going to have our student body vote as to whether they would like to have some sort of invocation prior to our football games. And if they vote yes, then we're also going to let them vote to select who that speaker would be. So the court, in analyzing it, looked at those facts. They certainly spent some time talking about the use of the word invocation as generally having a non-secular meaning, that it tends to rely on, calling from some divine guidance. And they talked a lot about the majority vote versus its impact on the minority, so that the people who didn't even want it to happen in the first place were going to be subjected to it. And then, likewise, their preferred speaker was probably not ever going to be selected by the majority. And the court really took a harsh view of the majority being able to overrule the religious rights of the minority.
So, how in the world do we get from a student speaker, and the whole point in Santa Fe was that there were some court decisions by this point that tried to make clear a student-initiated prayer, a voluntary student-initiated prayer, was perfectly constitutional. You couldn't discriminate against them any more than you could discriminate against whatever people were otherwise allowed to do and say, okay? So they were trying to turn this into a student-initiated prayer. The problem, according to the Supreme Court, was that the school controlled everything. It's impermissible. It sends the ancillary message to the school folks, the non-adherents, that they are outsiders, not full members of the community. And another message to the adherents that they are somehow insiders and favored by the school, that they are favored members of this community. And when you deliver that over the school's PA system, according to the court back in 2000, by a speaker representing the student body who's supervised by the school faculty and pursuant to a school policy, this is why this is an area of the law where we say, be careful about school policies. They will get you in trouble every time. It's easier to defend something else than a policy. So this can't be characterized as real student-initiated speech or prayer. This is the government entanglement of such. I put this in just because I like the first line. High school home football games are traditional gatherings of a school community. They bring together students and faculty as well as friends and family from years present and past to root for a common cause. Oh, but we could return to those Friday night light years, For many others, the choice between attending the games and avoiding personally offensive religious rituals is in no practical sense an easy one. The Constitution demands that the school may not force this difficult decision on students or, for that matter, on parents or others. So it's saying this is such a big part of the community that for the school to impose a Christian prayer, even through this process, violates the Establishment Clause again. Yes. So we're back to that. We're going to move forward again. We've talked about this case, but it's important to move from that decision to Kennedy. In Kennedy, what were the facts?
So this was a high school football coach who, I think as Phil mentioned earlier, at the conclusion of the football game, would go to the 50-yard line, kneel, and offer a prayer. Now, he didn't say that players had to come with him. Sometimes players did join him. Sometimes members of the opposing team would join him. But he did this for a number of years. At some point, the school became concerned about it, told him, "You're not going to be able to do that any longer." He said, "I'm going to continue to do it." They suspended him from that position. And the school district had a lot of arguments and concerns about how it would look with their coach on the field so close in time to the school activity. He was still technically on the clock, even though it was a time period when, he didn't have to be immediately supervising students, or there were some statements in the case about, he could have been talking to a colleague or doing something else. Regardless, the school district had the concern of that sort of excessive entanglement. They were making the Establishment Clause argument of, we don't want it to look like our school district is putting forth this prayer at the conclusion of the game.
It was not, and the court goes to great lengths to say this, certainly was not the prayer itself that was the issue. I mean, he could have prayed on the sidelines. He could have walked out of the 50-yard line and prayed silently. It was the kneeling, the showing, and the overt nature of the religious symbolism that led to the concerns, because they were still thinking Lemon versus Kurtzman, okay? And if you apply those three tests, then, and you're the school, you become really worried about that. However, even by 2022, you're well aware that you're between a rock and a hard place, if you will, because you fear the Establishment Clause lawsuit, but you also know that the community, at least a substantial part of the community, very much favors the coach and the actions the coach is taking. So where are you in that process, and what do you do? I've often thought this would be a terrible case to have actually handled, because I can see the client saying to their lawyers, "Let's just let him pray. Why do we care?" And the lawyer saying, "Well, we got a problem with the Establishment Clause. We may get sued by such and such, and et cetera." So it's that kind of situation. The Constitution, the best of our traditions, counsel mutual respect and tolerance, not censorship and suppression for religious and non-religious views alike. That was a sentence copied in one of the dissenting opinions in the book case, the Mahmoud case that we looked at earlier. They said the same thing. Well, this is the majority of the court trying to make that point. We won't get into the facts too much, because they're really not the point here. It says that he prayed on his own. Over time, some players asked whether they could pray alongside him, and he said, "It's a free country." The number of players who joined him eventually grew. You can see the picture there. If you don't recognize, right at the top of the screen, that person's holding a TV camera. So the number of players who joined him grew. Team members invited opposing members to join, et cetera, et cetera. Then he starts giving a short little sermon at the same
Motivational speech.
a motivational speech, okay? And so now we can, I'm glad this is the last one. Now we can just see that the next thing is an altar call, right? Isn't that how you end the service usually? So he made these motivational speeches, and by the way, separately, the team had these pregame and postgame prayers in the locker room, and guess who led those prayers as well? It was Mr. Kennedy. Here's the point of what we're trying to say. This court in 2022, very recently, say, you've looked at it wrong. You can't take each of these clauses out of the sentence separately and distinctly and throw them up there. They work in tandem. Where the free exercise clause protects religious exercises, the free speech clause provides overlapping protection for expressive religious activities. So now all of a sudden we got the free speech clause thrown in there together with the free exercise clause. Where's the establishment clause in that sentence? You know, sort of two against one. Nobody's talking about establishment clauses anymore. So it goes on to make the point that we've made several times, we're not going to dwell on this, that the district, under the facts, we want to get to the reasoning itself. The district said this was essentially a violation of the establishment clause. Mr. Kennedy said he was protected by the free exercise and free speech clauses. That's my two against one argument. His rights were in direct tension with the competing demands of the establishment clause, according to his argument. And the Ninth Circuit Court of Appeals had the same line of thinking. But according to the Supreme Court, they were all wrong because looking at them as separate units is not the way to do it. The three clauses appear in the same sentence of the same amendment, and they give you the thing again. Thus, they serve complementary purposes. Okay, fine. Which complementary purpose? You know.
Right. Well, and another interesting thing about this case is it was on a motion to dismiss.
Yeah.
And one of the points that the court did make was that the school district was raising these concerns of what they were afraid of with respect to the establishment clause, but they didn't have any facts in the record on that. And that's because at that early stage, you only get the facts that are pled by the plaintiff, who was Mr. Kennedy. So could there be a different outcome if you got this case at a different stage in the litigation, if there were people complaining about the infringement on their rights?
Yeah, I have said several times, in fact, I said in this conference when we were talking about this case, this is a case that if all the justices had agreed the facts were like the majority put them, it would have been a unanimous decision. Similarly, if all of the justices had agreed that the facts were like the dissent presented them, you would have had a unanimous decision in favor of the school district. So facts are important, and how you look at those facts is critical. You need to be able to recognize, wait a minute, this is one of those that Phil and Beth talking about, Golly Pete, where are we? You know, which side are we worried about the most? So, naturally, this is from the court again. This is quotes from the court. His proposal to pray quietly by himself on the field would have meant some people would have seen his religious exercise. Those close to him might have heard him too. That's assuming he was praying out loud. But learning how to tolerate speech or prayer of all kinds is part of learning how to live in a pluralistic society, a trait of character essential to a tolerant citizenry. This side of the court in this time wants to talk about tolerance in terms of religious groups, but not in terms of LGBTQ groups, gender identity issues, okay? They draw a sharp line between the two. In fact, religion for them lines up on both sides in favor of the religious prayer, against the practices of the books being in the classroom. So, here it is again. In all First Amendment cases, the facts are critical. What is it that you want to accomplish here? And I would urge you that the answer to that question more or less depends upon who is likely to challenge the decision you're making. Where's the challenge likely to come from? What's going to make the news and what's not? And then how much is it worth? These cases last forever. They cost a lot of money, and if you lose any portion of them, you end up paying the plaintiff's lawyers as well, whichever side wins. So you've got to think carefully from the very beginning, if you can, what are we after? You know, what's the goal here? And how do we best accomplish that given the facts of the case? All right, before we talk about Mahmoud, let's go back in time and talk about another curriculum case, Edwards versus Aguillard. In the Edwards case, we had the same sentence about boards having considerable discretion. At the same time, we've necessarily recognized that matters of education must be exercised in a manner that comports with the First Amendment. This is a case, and those facts aren't in here, this is a case in which challenges were being made to the teaching of creationism. Okay? So the issue was, can the school system prohibit the teaching of creationism, or as some parents wanted, could it allow or require creationism to be taught in conjunction with, or at least with equal time with, evolution? Most of you alive, most of you are old enough in this room to remember those debates. Started in Scopes and the trials in Tennessee and continued on for many, many years. It was basically a curriculum issue, okay? Because the school system was saying, we're not going to teach creationism, and the suit was being filed by those who wanted the option, started to say the opt-out, in this case it wasn't, the option to determine whether or not that was appropriate. Decision by Justice Brennan, 7-2 decision. And then we briefly are going to talk about Mahmoud again. Not to rehash the facts, but to compare it to families entrust public schools with the education of their children, but condition their trust on the understanding that the classroom will not purposely be used to advance religious views that may conflict with the private beliefs of the student and his or her families. In many ways, that's the same language that Mahmoud is using in a very different context. So, this goes into some of the facts that we've previously talked about, including the disruption of children's thinking and the opt-out provision, and about the government burdening the religious exercise when it requires them to submit to the instruction that poses a very real threat. Okay. Here, this poses a very real threat to parents. In Edwards versus Aguillard, where we're talking about creationism, it apparently doesn't pose that substantial a threat because the court is fine with the school district making the curriculum decision, not with each individual parent making it. We have this language again that you've already seen about the rights of parents and substantially interfering with the religious development of a child. And you notice that the court, just like we've been talking about, says this is always very fact intensive. For your purposes, fact intensive means we can't draw sharp lines. And it means we've got to know all the facts before we can make an informed decision. And we've got to look at all the facts from, if you will, I hate to use this terminology, from both sides. Who's going to argue what? What's that going to mean in the argument? It may have been a difference that Mahmoud involved very young children. That may have mattered. The court mentions it several times. But the question is whether the educational requirement or curriculum at issue would substantially interfere. Believe me, I litigated some of those creationism cases, and the parents involved in those cases strongly believed that not teaching creationism, or at least letting their children opt out of evolution, was substantially interfering with their religious development. So you see the court on different sides of the same thing. So what steps should be taken to deal with any curriculum issues that could be challenged? Number one, most of the time you're well out of those. As a Board of Education, you don't get involved in classroom decisions and specific decisions. Many times the answer can be simple and an opt-out or assigning a different book or a different assignment can solve the problems. But how far does Mahmoud go? Are there other issues, say vaccinations, where people argue that religion, and what happens when that argument leads to an outbreak of measles, if you will? Recently, we have had the Fifth Circuit Court of Appeals rule that the law has changed so substantially that the 10 Commandments can be posted now back in schoolhouses in certain ways. In Indiana, the governor actually filed a motion with the judge asking that a 40-year-old case prohibiting the 10 Commandments from being posted be removed, that case, that injunction, be removed in light of all this new cases that we're talking about, this new approach that's being taken. And the judge wrote a short little opinion agreeing. We'll see where that goes. We don't know. We'll see if any of these 10 Commandment cases make it to the Supreme Court, and we'll know more. But it's hard to see where the Mahmoud decision, what if the 10 Commandments had to be posted in each classroom and a Hindu student objected to a religious icon, if you will, in the classroom? How would we deal with that? How are we going to deal with these issues in a pluralistic society? All right. I think we've just about covered that. The First Amendment, religion and speech cases. Beth, I frankly think they are among the hardest to litigate that exist. And I think that's true because oftentimes what we think is the law and what the other side thinks is the law are incompatible with each other, but both of us have authorities to support our position, depending on where we look.
Right.
Okay. I think they're the most frequently litigated in many ways. We've certainly had an onslaught of them recently. Written directive policies. By that I mean policies that tell teachers and administrators what to do exactly are very dangerous. And that's because the law in this area changes so frequently. We hope we've shown you some of that. Everything about these cases is nuanced. It's hard to get a handle on a black letter rule in any way. It's often easier, frankly, to attack a written policy than it is to attack the action taken by an administrator. There are many reasons for that, many legal reasons for that, but the easiest reason is if you got a written policy, you know what you're attacking. There it is. You can go right at it. If you've got an action, you've got all these explanations of why you did it and what happened and et cetera. And, having said that about policy, turn it on its head. Training school and district leaders as to the potential litigation issues is imperative. We get letters. I bet in our firm we get 2 letters at least a week or more from the Freedom from Religion Foundation, which is totally the other side of some of these freedom of religion folks that we're talking about, accusing school districts and school employees of violating the Establishment Clause by what they do. So you've got folks pushing on this end, folks pushing on that end. You've got to consult with your lawyer and think about where the greatest risk may be as you deal with what are very, very difficult issues. And that brings us to the Marabelli case that we started with earlier. We're not going to talk about this case long. It's just to bring the 14th Amendment into the case, because all of a sudden we're talking about due process and the precedent of due process and the primary authority with respect to the upbringing and education of children. All these other cases up to now have been about the establishment of religion, have been about the freedom of religion, or have been about freedom of speech. You even saw some of that language. This case is about the 14th Amendment substantive due process. If rights get enshrined in the if the court enshrines parental rights to make individualized educational decisions as part of our Constitution, then we're going to have a real problem in public education dealing with different parents that want so many different things. All right, and I think that is close to through. That's the Little John case we talked about. All right, here's the list. I'm going to do the questions. Beth's going to do the answers.
Oh.
Because I know the questions. How do you know which part of the First Amendment is at issue in the school environment?
Just assume all of it.
Okay.
I mean, look at the issue that's coming up in front of you. But yeah, I think what we're seeing now is it's going to be the interplay of all of it.
How far is it safe to lean toward free exercise and ignore more of the establishment of religion approach? Is that safe?
Nothing is safe.
She gives answers like I give answers.
But if we are looking at the trends of what our recent Supreme Court decisions say, then yeah, it does lean more towards examining that sort of individualized free exercise and the implications versus the establishment clause. But you can't rule out the establishment clause. I mean, historically, we know we're going to loop right back around, right?
And the issue is, people say that to me all the time, you got to get to the Supreme Court. And to get to the Supreme Court, you got to go through a lot of litigation, a district court decision, or maybe a jury trial, but probably a district court decision, an 11th Circuit decision, and then get the Supreme Court to take the case. Then you can say, oh yeah, in Mahmoud you said such and such. Until then, you're dealing with other judges that are going to have their own interpretation of what these cases mean and say. All right, if free exercise and free speech are to be read together, because they're in the same sentence, okay, then when is the Establishment Clause involved?
Well, I think you've got to read it all of it together. It's all part of the same sentence, right? It's all part of the same amendment. And that's what, I forget which decision now, but it said you've got to read all three together and not just take one out in isolation.
And then the question that I've asked several times, and I know some of you are tired of it and some of you don't even like it, and I'm sorry, but how broad and what is going to be included in the parental rights that are discussed in these cases as potentially constitutional? How far do we take that?
Well, I think that's probably the million-dollar question.
Okay. When do parental rights trump, and I use that word advisedly, when do parental rights trump the school's needs? And I think you're seeing that over and over again in some of these cases.
Yeah. I think that's where some of the advocacy is going to come into play in terms of demonstrating those clashes and advocating for, the management of public schools and the operations of that in terms of those parental rights. We see it here in our own state with the Parental Bill of Rights that's been enacted more recently and giving more rights to parents and making those more explicit. But at some point, those two things are going to push too hard against each other. So I think we're going to see the conflict, until we get some more guidance from the court on just how far they're going to let it go.
And one more of these legal kind of issues that we won't spend much time on. Is this a First Amendment issue or a substantive due process issue? Maybe one, maybe the other. Who knows? Sometimes the answer to that question, to be really candid, is up to the judge writing the decision to get to the outcome they want.
Yeah.
All right. To me, this is the question that is important. How do administrators, much less board members, you get it once it's happened, okay? Most of the time. You get it once it's happened. How do administrators analyze those issues on the run and avoid lawsuits? Folks, I'm telling you, that is hard these days. Very, very difficult, because sometimes either decision could lead to litigation. All right, here we are. We are running almost 20 minutes ahead. If you'll get back here by 2:15, we'll keep you on that schedule and get you out of here to whatever you're doing back there in Savannah earlier, okay? See you in just a few minutes.
All right, we are going to bring back Phil and then Lauren for our last session of today's workshop. Enjoy.
You're the only one that got applause. Okay, folks, let me take just a moment of personal privilege. And many of you have met Lauren at other settings or in other seminars. We've done smaller seminars, but for many of you, this is the first time. So let me introduce Lauren Atkinson. Lauren is the first full-time in-house counsel for the Georgia School Board Association. She's assumed that position January 1st, and she has been gradually pushing me out the door. No, we have worked very closely together to try to make sure that she understands as much information as I can provide to her about what the job's about, what GSBA is about, and frankly, what you all are about. And you're a motley crew, if I do say so myself. So we have been working very closely at that. Lauren is very bright. She has experience with working with another educational association representing teachers and has come over from the dark side to the light side. And we very much appreciate her having me. You will see and hear Lauren's intelligence and brightness and personality. So I strongly invite you during the next, this afternoon, tomorrow, and Wednesday morning to get to know her a little better and to meet her and talk to her. Okay?
Thank you, Phil.
See, I told you, you're the only one that gets applause. All right, from the esoteric to the practical, or as some would say, from the ridiculous to the sublime, whichever way it is. We want to talk about something that is much, much more nitty-gritty for school board members. And while most of you will not deal with this on a meeting-by-meeting basis, when it comes up, it's a big deal for your school district. And I will tell you that the firm has had lots of requests for help in understanding the board's role in how to serve as a judicial body. So we're going to do a little bit of introduction, talk about the different kinds of ways this manifests itself for school boards, and so hopefully end on a note where you can take some very practical stuff back with you. First, it is, we talked about who interprets the law. Board members, let me get this right, because I tried to change what we had here and I couldn't get it done. It is not the three hats of the school board member, it's the three hats of the school board, okay? And it's not that the member is playing this role individually as a judge, as a legislator, as an executive, but that all of the board members have different functions that fall within these roles. We think of board members, we think of boards as being the legislative side of things, because your role is to pass policy. But I hope that most of you in the room by now have heard me say, policy does not mean just the pieces of paper, just the, whatever we call them, just what's on on assembly and on your e-policy. It's a much bigger picture than that involves everything from strategic planning to budgeting to hiring a superintendent to holding a superintendent accountable to monitoring your finances. All of those issues are policy issues. So that's your legislative hat. But sometimes, especially in Georgia, if you really look at Title 20 and open the book and start reading, you will see that the board ends up with an awful lot of executive responsibilities. This does not mean they're micromanaging the superintendent. This just means the law imposes certain things on the Board of Education to do. with the superintendent's recommendations almost always. And then finally, what we're going to talk about here, you do get to play the role of judge. At least, the bench with 5 members, 7 members, whatever you've got, where you hear appeals, where you hear hearings, and where you've got to review the evidence. And the point of this session, big picture, is how you act, how you approach an issue depends on what hat you're wearing. Yes. All right, so we start straight out of the Georgia Code because we're going to talk about the judicial role almost exclusively from here on out.
Yeah.
Okay?
So if we look at statute 1160, when we talk about 1160 hearings, local boards of education shall constitute tribunals. So that turns you into the judges, right? That sentence right there is that key language. For hearing and determining any matter of local controversy. It's going to be super important there. We're going to go back to it, but I really want you to pay attention to that, any matter of local controversy. And if you keep reading, in reference to 2 things, the construction or the administration of school law.
And we're going to spend some time sort of talking what those key phrases that Lauren just pointed out, what they mean. But the statute goes on to really place you in this judicial framework where whatever you do under this authority can be appealed to a higher tribunal in some way. So it talks about a right of appeal to the State Board of Education, and it talks about a right to appeal from that decision to the Superior Court of the county where the local board is located. It was very rare early in my career that we ever had a local board hearing where the decision went all the way to the Superior Court, much less to the appellate courts. Happens a bit more frequently these days.
It's a little different now.
It says a little bit about our environment that we're living in.
Yes, yes. And so we kind of covered this a little bit when we were unpacking the 3 hats, but I think the greatest skill that you can learn when you're acting as a board member is identifying which role you're carrying in that moment, as a board and as an individual, right? And so just remembering in the broadest sense that the legislative is that policy and including the budget priorities, executive is that superintendent accountability that's prescribed by law, and required approvals, of course, that we know come from law as well. And then that judicial is what we're focusing on today, right? But we know that all 3 of those hats can sometimes come into play with the role. But I think Phil framed it beautifully. For me, when I was on the dark side, and I will also say I was a former teacher as well in Georgia, 1160 hearings are pivotal, right? These are landmark decisions that affect employment, pay, student discipline. These are sometimes life-changing decisions for what's before you. And so I really want to frame that for you all, that there's a lot of power there, there's a lot of duty, man, there's a lot of obligation in that.
And even though you don't do that as frequently, when you do it, Lauren's point, it's very important. Okay, we're going to do a little bit of a history lesson. I know we've done a lot of that. You're going to say, oh no, don't do this to us again. But a little bit of a history lesson to tell us where we've been with interpreting this statute and where, at least I think, we are now. Glenn County Board of Education versus Lane was a decision that I knew well back in 1991 that involved an argument about whether the Glenn County Board of Education, which was required under its local act to have a private auditor, whether or not the state auditor could fulfill that same purpose, okay? And as always, we had a citizen in the community more than willing to file a lawsuit and challenge that decision. We want to focus not on that issue, but instead on the interpretation of 1160 as it was applied by the Supreme Court in that particular case. A Board of Education is the governing authority. We said that. As such, it has the capacity to act as, here we are again, legislative, executive, and judicial bodies. 1160 provides in its judicial capacity, it conducts hearings, makes decisions, and there's the same language straight out of the statute. The terms local controversy and school law have never been defined by this court. How often do you see that in decisions? We don't know what this means. Nobody's ever defined it for us. And so the Supreme Court said, ultimately, we're going to affirm what the lower court did because this is not a matter of local controversy involving school law. Instead, it's a matter of a duty placed on the local board by a statute. So it's not really a controversy either way. It's a matter of interpreting what the local law says and what that means you have to do. Okay? So they got around it that way. What about public broadcasting versus Atlanta City?
Yeah, this case was interesting. It comes out of the Georgia Supreme Court, 1995, so a couple years after that case of Nguyen. And what's interesting about this is it's about a school-owned radio station. And this case was interesting in the concurring opinion from Justice Benham's concurrence. And I think this was probably more pivotal of a statement than I would say even the majority opinion here.
He voted in favor of the majority.
Yes.
Said okay, but he wanted to have his say
Yes.
as well. Any of you that knew Justice Benham would know that was true of him generally. So he, as he said, wanted to write separately for that purpose.
Yes, yes. Just a lawyer tidbit. Whenever you see a concurring opinion or a dissent, sometimes those are some of the juiciest pieces to read. And so this concurring opinion, I think, kind of gives you a good snapshot of what we were left with after public broadcasting, right? That I'm writing separately to express my concern that this court has not given school boards and superior courts of this state sufficient guidance in this area, right?
Exactly.
What are the definitions? What
Exactly
are we
what the
doing?
court had said in Lane, you know.
Right, right. So we're still in the same spot, right? And Justice goes on to say the majority opinion cites numerous cases applying or refusing to apply the statute, but it has not provided anything useful. No useful guidance still.
See, I can imagine some of you scratching your heads after that last session that Beth did so well, and we stood up here and cited to a bunch of cases, and you say, but you didn't give me anything useful, you know, out of that whole process. And that's sort of what Benham's saying. You cite these cases all day, but what does it mean? What does the statute mean?
Yeah.
You know?
And I think he puts the nail right in with this final statement, which I love, which he says, continuing instead with the case-by-case basis of which issues in that area have been decided is going to place an undue burden on those involved in public education. So look to your left and your right, your neighbor, right? Who's carrying that burden if we don't have clear guidance, right? And making it almost impossible to determine whether a particular controversy, case by case, is going to be first addressed through administrative procedure or if it's going to take some other avenue, right? So that's what we're left with in 1995.
We move forward a little more than a decade, and we have a case that sort of takes a different turn a little bit. And frankly, part of that is because it is a more specific individual versus school district controversy. In the Day case, suit was brought against the school district. And the complaint was, and Lord, I've dealt with these issues for how many years. The complaint was, Nguyen paid me the right amount for the last 9 years. The school system said, we gave you a contract every year. If it wasn't right, why didn't you tell us, you know? And so that became the lawsuit as to whether or not she was entitled to back pay of any kind. And she was arguing that she ought to get credit under the state board rule for her years of experience as a registered nurse. So she brought this claim, and it went on to the Georgia Court of Appeals eventually. Actually, it went all the way through the process. State Board of Education, Superior Court, and then up to the Court of Appeals. We're going to skip a little bit and just go to the Court of Appeals. And the Court of Appeals said, look, generally, if a teacher or an employee has a dispute about an employment contract, they got to go to the Board of Education and get redress from them in some way before, there. So they sent it back. That's what remand means. They sent it back to the State Board of Education saying, look at this again. Actually, they should have sent it back to the Superior Court, and they may have. But anyway, we're not going to argue over that. Thus, the Court of Appeals sends it back. The State Board says, this board concludes that the proper time for an educator to challenge credible experience is at the time of hiring under his or her initial employment contract. Thus, this appeal is not timely. We're not here today, right now, to talk about the merits of this particular case, although I agree with it. We've cited it many times. But we're here to say, here was a case where 1160 was the proper route to get the case up into the courts from the state board of it, from the local board to the state board, et cetera. And in fact, you have a state board rule that specifically says employees can contest the evaluation, verification, and award of experience under the provisions of 20-2-1160. One of the kinds of hearings that you might get into as a Board of Education with a teacher, although they don't happen much because of the day ruling under that. All right, so you want to talk about your little chart here?
Yes, the teacher in me had to make a visual. And so for me, I really wanted to be able to capture from the historical context to what we're dealing with now, today, right? So we just took you on a trip down memory lane. Let's bring us to the modern view. And I think this graphic kind of sums it up perfectly for you. In the historical application, you get these broad buckets, and you get this case-by-case analysis, and you get this undue burden on public education and you all to have to figure out, oh my gosh, am I the judge? What am I doing? Is this an 1160 worthy matter? Or am I just making this into something it shouldn't be, right? And you see those broad buckets of employment contract disputes, school construction disputes, pupil assignment matters, and other school law controversies. Remember, undefined, right? Now we go into that narrow, modern view, and that's what we're going to talk about going forward, which is we've still got those buckets that you remember of the matters involving the construction of law or administration of law, of school law, but now we've got student discipline appeals, we've got certain employment contracts of compensation disputes requiring school law interpretation, right? And then we've got statutory parent appeals, thank you legislators. We've got harmful material appeals, thank you again. And we've got divisive concepts. Remember, we've heard these, right? And so now we've got this narrow statutory defined things that are also making us possible judges in scenarios when triggered, right? And so that's what we're going to talk about.
Lawyers can get really into the weeds when they're trying to figure out what 1160 means. Because frankly, if you look in, I talked about the annotated code of the United States and due process. When you look at the annotated code for Title 20, and you go to 20-2-1160, there are a lot of old cases that talk about all kinds of things. I mean, anything that was a local controversy arguably became an issue for the school board to decide under some kind of a hearing process. We've moved away from that, and let's talk about how that's happened. Here's one example, and it's probably important to make this point. We've moved away from it primarily by state board decisions. And think about that for a minute, because if you don't have jurisdiction under 1160, then the state board doesn't have jurisdiction on the appeal. And if you don't want to have a hearing on where you ought to place your next school, do you really think the state board wants to have a hearing on where you ought to place your next school? So it has helped us define and corral some of these arguments that local controversy controls as opposed to matters of local controversy involving the construction of school law. Okay? So,
get into this state board of education case, and I will say, to frame this plaintiff, this is a bus driver employee who was non-renewed, but no contract, right? So we know our bus drivers usually not under contract. And I think that's important here, just for the outcome of the case, just to frame that. What came out of this was, most certainly the issue became whether the state board should decide a question that was grounded in general employer law, right? This seems like a typical situation. We've decided to not move forward with an employee for next school year. We've given the proper notice, and we are trying to go on with our school business, right? And that's almost how the state board viewed it as well, I feel like. And you see that coming out in the opinion where it says, therefore, the issue to be decided is whether under the principles of general employer law, appellate obtained any rights to continued employment because the local board's written policy limits termination to cases where there has been some type of duty assigned, right? Insubordination or immoral conduct. The interpretation of the principles of general employer law is the province of courts and not the State Board of Education. So you see them almost putting down that boundary of saying we're not willing to go into that territory, right? This is a general dispute, it does not need us, and we're not willing to enter into that arena.
And it gives us a better explanation for why it does that.
Yes.
In the Harris case, where it says the state board doesn't have jurisdiction to hear this appeal because it's trying to decide a policy. It's all about a policy of the board, not about a law, not about the construction of a law. Nor does the incident involve the construction or administration of the school law. There's nothing about Title 20, now it's focused on Title 20, that requires the local board to take action against a teacher about student complaints. This was a typical student complaining about a teacher. Don't ask me why. Many of you have these kind of crazy policies. I've said it before, please get rid of them, that allows a student or parent or anybody else, if they go to the parent, if you go to the classroom teacher, then they go to the principal, then they go from the principal to superintendent, then they get to the local board of education. Why? They shouldn't get to you in most of these cases ever, okay? And that's what this court is sort of saying. This is all about a policy issue. This is all about a school dispute. This isn't a Board of Education judicial matter that they're hearing, and therefore we don't have jurisdiction of any appeal under this. This back to employer-employee relations again, where, yeah, you like that, don't you? Some of you know people like that, I'm sure.
I think I got that call once or twice. And just to frame, this is once again a non-certified employee, no contract, just to kind of set the scene for what rights they may or may not have. I think very importantly here, this was an alleged educator The facts are pretty funny when you read the case. This educator was alleged to falsify their reporting time and their leave time, actually doctoring their Chronos clock in and clock out machine. And so those are the facts that were pled and alleged, that this educator had falsified their work records and their work hours. They brought a claim, and the state board found no jurisdiction, right? Once again, setting that boundary down of saying this is not an arena that we have to get involved in. And you see that language again. Employee-employer relations are not part of school law. There is nothing in Title 20 of the Official Code of Georgia that addresses the right of employees who do not have a contract and who are not certified. Remember, I framed that.
You more and more find the state board equating school law with Title 20.
Yes.
Okay?
Yes.
And that becomes really important. If it's not something under Title 20, we don't have anything to do with it. Sorry.
Oh, you're fine, Phil. The decisions of the local Board of Education concerning its employee-employer relations are purely ministerial actions and do not fall within the realm of school law. There is nothing unique about such relations that provide the State Board of Education with any special expertise that it should review such decisions, any more than it would review the decision of any other employer to discharge its employee, right? So in a nutshell, we are not the experts here, you are. This is a matter of local control, this is procedural, this is your employment, this is your staffing, and this is an employee who did not have any special rights under Title 20.
The other part of that I think is really important about that last sentence, which I agree with Lauren, is just key, is that, wait a minute, if you've got a remedy, not saying you do, take it to court. But this isn't an issue that goes through the school board because it doesn't involve something that particularly involves us as a tribunal and our expertise in this area. And then we got one more.
Oh boy, extended day pay. Got a lot of calls about that too when I was on the other side. So this is a certified special education teacher who felt like she was not getting the extended day pay. I think they had a policy, took it away, et cetera. And so her argument was that the staffing assignments and the eligibility for the extended day pay were interpretation of administration of law. Or that was the issue, I would say, right? That's the tension there. Is that an interpretation or an administration of law? The holding of the state board, you see kind of reflected up there in that quote, they dismissed for lack of jurisdiction. And their main point was teacher assignment decisions and extended pay day eligibility are treated as internal operational, right? And you see that in this instance, the controversy does not appear to implicate the construction of school law. The issue here relates to how the local board staffs its schools. It's the same echo, it's the same thread as the case before, right? We're giving you the expertise, you are the expert in your county to staff it correctly. Let's not turn this into, we've got a route for Superior Court or State Board to come in and tell you who you have to hire, right?
So, we've looked at the possible times, some of them, when the local board acts as the trial court, if you will. Something most of you are much more familiar with is where the local board acts as the appellate court, particularly from a student discipline tribunal point of view. And how does 1160 work into that, and how are those rules applied?
So the provisions of Code Section 1160 shall apply to the disciplinary proceedings under this subpart, right? And so you see how it ties into that 754 subsection A. And it talks about the disciplinary officer, the panel, the tribunal shall conduct the hearing. It sets up the evidence, rendering a decision. It talks about the decision shall be based solely on the evidence received at hearing.
And we have more problems with this when this gets on appeal to local boards than anything else.
Yes.
If it wasn't heard and decided and there was evidence presented to the tribunal, forget about it. It's not relevant to the case, period. I don't care how many of you heard it at the Publix, while you were shopping. It's not related to the case from a legal point of view on appeal to the board. And then it talks about there is a right to appeal to the local board. So what does the local board do then when there is an appeal?
When the appeal occurs, the local board shall review the record and shall render a decision in writing. That decision shall be based solely on the record. I wish I could have that on a megaphone because that's where we get into trouble, right? When we are not applying the right standard of review, when our judicial hat is on as a board, we're endangering our decisions, right? We can't protect that decision, and we've almost made it very vulnerable, right, upon review that they're gonna say, did we misapply the standard of review here, right? And so that's why I say if I could hone on anything that you're gonna remember from that slide, it's the decision shall be based solely on the record when you're in that appellate court 754 type of judicial hat. Neither the state board nor the superior court shall consider the matter de novo, right?
That says in essence the same thing.
Yes.
You don't consider the matter again, you don't take new evidence, you don't start over, you take what you've been given, the decision and the evidence, and decide it from there.
You are confined to the record. And so how important does the record become then? Becomes very important, right?
That's why we spend so much time trying to train your administrators on how to conduct student discipline tribunals, etc. We still have the Fair Dismissal Act in Georgia. A number of school districts, charter systems, and strategic waivers have waived the Fair Dismissal Act, but many school districts have not. And so the Fair Dismissal Act, certainly when I was first practicing school law, was the most prominent way that a Board of Education would get involved in hearing a case. There are a lot of those, and boy, do I have some stories for you. But anyway, so the hearing is conducted before the local board. The local board can delegate a tribunal. Occasionally it will do that. Many times it will not. All questions related to admissibility of evidence and other legal matters are decided by the chair or the presiding officer if you got a tribunal. The burden of proof is on the school system, preponderance of the evidence being the burden of proof, okay? More than 50%, just enough to tip the scales. That's the standard that you apply. Now that's different than the appellate standard, which is any evidence. Here's the evidence. If there's any evidence that the tribunal was right, you uphold what they decided. That's very, very different because you're not the initial decision makers. Here, you are. And so we've got preponderance of the evidence as the standard. Same rules governing non-jury trials in superior court. That means something to the lawyers, doesn't mean much to the rest of us. You got to make your decision within 5 days. Most of the time, it's made immediately. Where the hearing is before a tribunal, it talks about what that process is. These are the two most frequent examples of the board acting as an 1160 tribunal. Fair Dismissal Act hearings and on appeal of student discipline cases. There are three more that we're not going to spend a lot of time on. You will remember that 3 or 4 years ago when these were passed, you will remember we spent, always bothers me when this camera is over here and I can't hold my stomach in that long, it just cannot.
He's got to count us down so we can hit a pose.
Oh, gosh. Anyway, we have the three statutes that we talked about in a whole session here. the Parent Bill of Rights, the harmful materials. In these particularly, one of the things that's essential for the local Board of Education, do your best not to allow this to turn into a policy or a political referendum, okay? That's just going to make a mess out of it. Know your role, know what the issues are, listen to the evidence, make the decision, okay? So let's talk briefly about those three situations and some of the differences between them.
Yes, so we've got the first step for our first statutory hook that we've talked about is the Parents' Bill of Rights appeals. So that's coming out of Section 786, still Title 20. You'll notice the theme there. Any party aggrieved by a decision of the local board rendered on a contested issue after hearing shall have a right to appeal therefrom to the State Board of Education. That's that 1160B hook that we've talked about. The right to request in writing from the local school superintendent or school principal the information provided in the code section. The school superintendent or the school principal shall produce such information, inspection. You all remember that trigger that now comes from the Parent Bill of Rights that we have to reckon with, right? If the local school superintendent or principal denies the parent, then you trigger into that 30 days and the timing of all that. Here's what we get into. The parent may appeal such denial or failure to respond to the governing body.
Go ahead, I'm sorry. Finish.
That governing body must place such appeal on the agenda for its next public hearing.
This is sort of an in-between. This is sort of an original hearing that can be held by the Board of Education under some circumstances, but it's often an administrative matter that acts more like an appeal to the local board from the decision of the superintendent, okay? So it's a different kind of animal, and this is a totally different kind of animal, because here you're reviewing these harmful materials. We're not going to go through the whole statute, that's not our purpose, but look at what you're doing. Appeals of the school principal's determination. By the way, they come directly to you, they don't go through the superintendent. Appeals of those determinations are subject to full administrative and substantive review. I don't know what the heck that means, but it's not any evidence. I know that, okay? It's something more than that. And so the board is going to play the role of a fact finder in that situation to a much larger extent than some of these other situations that we've talked about. And it really gets confusing because the parent can show up at your public participation and have their right to have their say. Well, now, is that supposed to be part of the record? Are we supposed to have a court reporter there? What is that? Right. You know, so it's a very confusing kind of process that's obviously different than the Parental Bill of Rights because it clearly anticipates a more involved review by the local board. And the divisive concepts appeals.
Yes. And I think this is why it's so important when we talked about those three statutory hooks and Phil said, be careful here to try to make sure it doesn't become a political referendum, right? Because you can tell just by the nature of some of the complaints that the statutes can elicit, it's going to be very easy to, if we don't watch this, slide into having a referendum about a certain issue instead of just doing the duty that's prescribed to us by the statute in our judicial role, right? And so we get into divisive concepts, which I think can be slippery when we're trying to do this. And it talks about the local school superintendent's decision following the review provided for in subparagraph E shall be subject to the review of the local Board of Education.
And frankly, I'm not sure I know what that means, you know, because the local superintendent, so does that mean the local superintendent's on one side and the complaining parent often, is on the other side? It's it's just not crystal clear. What's clear is you're supposed to have a hearing under 1160 of some kind while at the same time protecting confidentiality of student and personnel records in some ways.
It is a thin thread that you all are having to weave, especially with these new statutory hooks. And so it is definitely something where I think if you remember what the statute is asking you to do and that standard of review, what standard of review is applying here, right? That's going to keep you safe here. And that kind of brings us to some, I think, best practice tips. I would say these are your takeaways and your walkaways that will keep you protected as you're moving in those judicial spaces and roles, right?
No matter whether you're playing appellate,
Yes.
no matter whether you're playing the original tribunal, no matter which of these statutes you're under, these rules, these suggestions, these best practices apply always.
Yes.
Right?
Avoid prejudging the situation. I think that is sometimes really hard in the world that we live in. We all have our personal opinions, we all have our personal beliefs, et cetera, et cetera. I myself hold my own, right? But it is best practice in those moments to avoid prejudging whatever you think the outcome is, whatever the facts are, whoever the guilty party is, et cetera. That's gonna keep you the safest, right, as you're executing your judicial role. I also will tell you in my prior life, the calls of the independent investigating board member, they always helped my side, right? You wanna be careful there. You wanna be very careful that you don't go on your own fact-finding mission to bring something to the board that may not be a part of the record, right? And now what have we done to our decision? Because maybe I want it to be helpful and bring some really juicy facts that I got at Publix on Friday from a constituent. I've gotten the calls, right? And I want to bring it to you all because this informs our decision.
And it's important.
Right, it's so important. I mean, this is exactly what we're deciding. And so I bring it to you and I share it and we base our decision off of that. Phil, is our decision safe now?
Yeah, well, it's much the same thing when you say avoid receiving one-sided information. I mean, that's much the same argument. If you're going to be the judge or the jury, then be the judge or the jury, not the investigator that's out there. And certainly, you wouldn't believe how many times in my career I've had board members that got so mad because the community couldn't understand why we didn't fire that principal, why we didn't get rid of that football coach. That's usually what makes them the maddest. Why we didn't do these things, you know, and inevitably some board member will say, well, we got to give them a hearing first before we fire them. Little something wrong with that process because you got it in your mind that you're promising a certain result and they're going to try to hold you to it. And obviously your decision ought to be based on, once again, the record, what you get, and the law as provided to you by whoever the party is, the hearing officer, your lawyer, whatever, in the process. All right, let's look at a few more issues from a very, very practical point of view. A little bit like the preaching we were doing earlier, but that's okay. We'll do a little bit.
Sometimes it's a wraparound of the same message, isn't it? This is, I think, a good way to package what we've been talking about, right? The best way to protect yourself is when you're wearing that hat that we talked about, the judicial hat. You're to act like a judge. You all have so many other roles that you take on, right? And a lot of that is dealing with constituents. And sometimes when we're putting on that judicial hat, it's really hard to understand we're not constituent services at that point.
But it's hard because you are so much of the rest of the time.
Yeah.
And because you rely upon these people to elect you to office.
Yes.
And you, quote, represent these people.
And
so,
we, of course, don't want to alienate them, right?
So turning that hat over and around or whatever you do with it is really difficult in these times.
Yeah. And
So-
of course, we're not saying you don't respond to constituents. We're not saying you run away, right? And so this may mean that you have some practice language, right? That you've already practiced in the mirror because you know it's coming when you go to Walmart on Saturday, and you know what you're going to tell Paula when she asks you what's going on, right? And that's going to protect you. It means that you have to recognize that this matter may come before you later. And in order for you to be involved, you've got to protect yourself from receiving this information that makes you an independent investigator, where maybe now you're going to have to recuse yourself rather than actually representing your constituents.
Best conduct includes referring the person, if at all, to the right process. Often that just means you need to see the superintendent, okay? Maybe sometimes the principal on one of those 3 nails or whatever you call them, hooks that we put in there. It certainly means preserving your neutrality. Folks, good lawyers and good judges can have really, really strong opinions about the case and never show it in what they say or how they say it. And that's your role in these things. Don't let it show. Don't talk about it. Don't ask questions in a way that makes them think you're the prosecutor, not the judge, okay? You can ask most of the time procedural or clarifying questions, but do it through the right channels. Sometimes you can do it directly, sometimes you do it through the hearing officer, whatever. But do it correctly and make sure it's a clarification, not an expression of an opinion. And then you deliberate, and for the 3rd or 4th time, you base your decision on the law and on the record. Final words? Ms. Atkinson?
I think I would close with what I began with. When I first started teaching and when I first became an attorney, 1160 hearings involved some very pivotal moments for folks. For me as a first-year teacher, student discipline cases and safety in the classroom in 1160, man, that was a tension. And then going on the other side and realizing as a baby attorney that 1160 involved a lot of stuff that really affects the livelihood of folks, right? And so I think you all know the weight that you carry, and you carry it well, right? And so what I want you all to take away from this session is best practices to protect yourself, so that when you do want to represent your communities and your constituents in these very important spaces, the decisions that you all make are upheld, right? That's the goal there. And so I want you all to arm yourself with just knowing, what hat do I have on, right? And what does that hat call of me? What does it stop me from doing, right? And I think that's going to protect us in those spaces. You all do so much for public education, and I think it's going to take all of us on all sides to do the heavy lift that's coming. And so I applaud you all. You probably don't hear that enough, but I applaud you all for the work that you do. Thank you so much.
All right, folks. Thanks for the applause, and thanks, Lauren. Give me 10 minutes, and I'll have you out of here. But I need 10 minutes. And I need 10 minutes, maybe even without your cell phone in front of you, if that's possible. Recently, there have been 2 quotes that I cannot get out of my brains to save my life. Number 1 came several weeks ago when Ted Turner died. And among the TV coverage was an interview that he gave. I don't even remember where or how, but he gave some time ago. He was a much younger man, but and his quote was, "Never set goals that you can reach." And I thought, that seems counterintuitive. Number one, I hope and think that in much of my career, that's been true, both in terms of representing you and representing public education, and in representing and in doing the best I can for my family and the profession. But I know it's true, and this is what really got to me when I started thinking about it. I thought, that's just wrong. And the other place it comes up, though, all the time is public education. You're the ones that say, no child, no child, no child left behind. Every student succeeds. What's your goal for your graduation rate? 100%. Yep. I'm not talking about whether or not you ought to be graded in some way on that. I mean, those are all different kind of issues, but those are your goals. And those are always the goals of public education. No matter what. So, if that's true, how do we get there? Take this to heart. I hope you don't take it personally. If you do something positive with it. Can you imagine? Can you even in your wildest dreams imagine what would happen if every board member in this state believed in public education? I'll take everybody in this room, okay? It's imponderable to me. And I'll go a step farther than that. Because as important as public education in this state is, it's public education in your community that matters to you. And that matters, excuse me, to your constituents, parents, even your taxpayers, and students. So what if, and I'll use 5, I know there's some differences. What if all 5 of you, sitting around your table on those Tuesday or Thursday nights, all believed in public education? I think you'd see enormous changes, candidly, if it was just one of you. But I go back to Turner's quote, set your goals higher than you can possibly accomplish. So what would that mean? For the next 2 days, and I hope many of you, if not all of you, are going to stay for the conference. And for the next 2 days, you're going to receive a lot of information from this stage. A lot of information from smart folks. But I'm going to propose to you the most important information you're going to see or hear is first going to come from these videos of your school districts that you allow GSBA to do, and GSBA comes out and does. It is amazing. Look at it as if it weren't yours. Be amazed. Be astounded at what public education in your community is and can do. But if that's not it, listen to the musicians. And if that doesn't do it for you, listen to the kids that get up here and talk from this stage. I have never heard one of them in all these conferences, never heard one that didn't believe in public education, because that's what got them to the stage, and that's what got them where they are. So what am I saying to you? If you believe in public education, and if what they have to say is that important, why are you keeping it in Savannah? Why don't you put these kids in front of your civic clubs, in front of your faith-based communities, in front of your PTAs and other school support groups? Let them help you build a belief in public education. Take those choruses and those bands wherever you can get them, even if it's, to the square, Friday night after football season is long over. Make the people in your community know the value that you are giving to them. I appreciate so much all of you showing up. It's a great crowd today, and we all appreciate it. It's really great to present to a full house like this. We'll be around for a while. But I said there were two quotes, so the second one, I'm not going to tell you where it came from. I might, if you ask me in the hall somewhere, but it's simple, and it has been up on my computer screen on a Post-it note ever since. And it says, "It went by so fast." And you know it did, many of you. And you know it's going to keep going by so fast. And it's you in those seats, around your board table, in your community, coming to these conferences that make it all possible. This is my last summer conference, as most of you know. I have every intention of being with you in December. Tell your neighbors, tell your friends, bring your animals, whatever it takes. But I really hope to see you there, and I hope you realize that believing in public education starts with you, and then it goes from there. We hope you enjoyed this. We'll all be around to answer questions. They'll be at the door. Thank you, folks.
Thank you, Phil. Thank you for always believing in public education. And just a few reminders for today, because in order for us to continue doing the great work that you do, we need to make sure we're meeting our training requirements and that you're getting your credit. So you have a couple of ways to get it. You can go as an attendee into the policy workshop session in the Feed Loop Go app, and then you can tap the check-in button. If you're having trouble navigating that on your smartphone or you don't have a smartphone, we have staff at the doors. We have staff at the doors who can check you in. You can also double check at the registration desk, but we will make sure that you get your credit. We want to thank you for coming today. We want to thank you for believing in public education. And we want to thank you for helping us celebrate GSBA's 75th anniversary. For more information, go to www.gsba.com. And we do have t-shirts for sale to support public education. Thank you and enjoy your time in Savannah. Let's get your credit and do your evaluation.